reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearings, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from the opposition. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of that allotted 10 minutes for the rebuttal. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because the BZA meetings are recorded for the Metro Nashville Network, it is imperative that anyone addressing the board come forward, sit at the table, and speak into the microphone. All speakers should identify themselves by name and address prior to making their desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the hearing date. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you're required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding cases that have been deferred. Case 2019-085 involving property at 1506 Church Street. That case has been deferred to May 2nd. Case 2019-134 involving property at 5101 Harding Pike has been deferred to April 18th. Case 2019-145, property at 800 Air Park Commerce Drive has been deferred to May 16th. Case 2019-149 involving property at 2019 19th Avenue South has been deferred to May 2nd. Not May 2nd, April 18th, I'm sorry.
That's the one that was just added late.
That's right, it was just added late and they have requested a 1-meeting continuance to April 18th. And case 2019-150 involving property at 423 and 425 Mallory Street has also been deferred to April 18th.
Would you mind giving the first case number again?
Sure, case 2019-085. And then on the short-term rental docket, we have a couple of deferrals. Case 2019-012 has been deferred indefinitely. And case 2019-118 has been deferred indefinitely. Ready? For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record these cases that have been so recommended. If anyone is here in opposition to one of these cases identified for the consent agenda, please wave your hand, make sure I see you and know you're here. So we'll remove the case from the consent agenda and hear it in its regular order. Mr. Chairman, these cases are those that have been recommended for the consent agenda. Case 2018-656 involving property at 3509B Renwood Drive. Is there anyone here in opposition to case 656? Yes, Mr. Chairman, we'll pull that one from the consent agenda and hear it in its regular order. Case 2019-122 involving property at 1524B 23rd Avenue North. Is there anyone here in opposition to case 122? Seeing none, the next case is case 2019-123 involving property at 1620 12th Avenue North. Anyone here in opposition to that case 123? Next case, 2019-124 involving property at 1540 12th Avenue North. Is there anyone here in opposition to that case? Next case, 2019-125, involving property at 5132 Cochran Drive. For the board's knowledge, this is a variance request to build an attached carport. The applicant has agreed to the condition that the carport not be enclosed. Is there anyone here in opposition to case 125? Next case, 2019-126, property at 811 Lena Street. Anyone here in opposition to that case? Seeing none, next case 2019-127 involving property at 2302B 14th Avenue North. Is there anyone here in opposition to case 127? Next case 2019-138 involving property at 1 Park Plaza. Is there anyone here in opposition to case 138? Seeing none, the next case recommended for the consent agenda is case 2019-139 involving property at 2526 Lebanon Pike. Again, another condition for the board. This is a variance from sign requirements to allow an LED sign. The applicant has agreed to the condition that the sign be dimmed at night and that it will not have any video fast transitions or flashing at any time. Is there anyone here in opposition to case 2019-139? Seeing none, the next case is 2019-144 involving property at 3912A Kaler Drive. Anyone here in opposition to that case? You might want to make sure it passes, but yes, if it does. Case 2019-146 involving property at 2203 Hobbs Road. Anyone here in opposition to that case? Final case for the consent agenda, case 2019-148, property at 921 Gallatin Avenue. Anyone here in opposition to that case? Seeing none, to review, Mr. Chairman, the consent agenda is comprised as follows. Case 2019-122, 123, 124, 125, 126, 127, 138, 139, 144, 146, and 148. Staff would solicit a vote at this time.
There's been a motion for the consent agenda, and we'll note that for anyone who is curious or interested, that in order for a sidewalk variance to be placed on the consent agenda based on our discussions and our rules, they have to meet the planning department's recommendation in order to be eligible. So each of those sidewalk cases that are on the consent agenda have agreed to the planning department's recommendations for that variance request. So there is a motion on the floor. Is there a second? Second. Any discussion? All in favor of the consent agenda say aye. Aye. Any opposed? The consent agenda passes.
Members of the public, if your case was just approved on consent, you are free to go. Please give our staff until Monday to process all the documentation in order to get your permit for which you have applied. Mr. Chairman, before we move on to the cases to be heard, we would like to take the opportunity to recognize any elected officials who might wish to address the board. Councilman Withers, would you like to address the board?
And Ms. Lamb, while they're coming up, I just would like to extend a welcome to our newest member of the board, Ashanti Davis. We're very proud to have you on the board and appreciate your willingness to serve on the board, and also to congratulate Ross Pepper on his first full-term appointment. He's already been on the board a couple of months and well-seasoned at this point, but we're glad to have you appointed to the board for a full term. So congratulations to both of you. And now we'll go to Mr. Withers.
All right. Thank you to the board members for your service. I know you have a lengthy agenda today, and Appreciate all the time that you're going to spend on those cases. The one case that I would like to address, I did send an email in reference to it, but is 2019-133 for property on South 19th Street in the Shelby Hills neighborhood. It is a short-term rental case. Council member Bob Mendez has also submitted a very detailed letter to the board regarding that case. The primary issue with that case is that it is, while there is a person who lives at that house, that it does not qualify for an owner-occupied a Type 1 short-term rental permit because the building is owned by an LLC, which is Aerial Development LLC. Aerial Development has been very active in constructing new homes in that portion of District 6 and in some other areas. Because they still retain ownership in some cases of those properties through their LLCs, those properties are not eligible for Type 1 permits. And of course, Type 2 permits are no longer permitted in R and RS zoning anyway. So on a technical matter, I cannot see a way to grant the applicant a permit for this. I would welcome any thoughts from Metro Legal on that, but it's not a case in which I have heard a large number of constituent complaints. It's just I simply don't see a way to grant that within the parameters of the law.
Okay.
So I agree with the analysis of my esteemed colleague, Councilmember Bob Mendez, on this one, and encourage you to disapprove.
And I know he wrote a letter that's in our case file too, explaining that exact same issue. So I appreciate you coming down and talking about it.
Thank you.
Are there any questions for Councilmember Withers? Great, thank you. Thanks for coming.
Councilman Freeman, would you like to address the board or wait? He'll wait. I don't think I saw any other council members, but want to make sure I'm not missing anyone. So absent any other announcements, Mr. Chairman, we're ready to proceed with the docket. And before we get started with the cases to be considered, Mr. Chairman, the first item on the docket is to elect a vice chair for the board.
Okay. I'll open the floor for nominations, and we'll start with nominating Ross Pepper.
I will second.
We have a nomination. Is there any other thoughts or nominations? Then we will have a nomination and a second, and all those in favor of Ross Pepper being our vice chair, raise your hand or say aye. Aye. Any opposed? I guess you could vote. Are you opposed, or did you?
I figured that.
All right, that's right. All right, well,
No, I'm not opposed.
All right, well, good. If you were, you probably should have spoken a little sooner, but because you're now the vice chair, congratulations.
Thank you.
Mr. Chairman, the first case for the board to consider is case 2019-089. The board members will likely recall this case. It was previously heard, failed to receive 4 affirmative votes. The request here is for a variance from the contextual setback requirements. I believe Ms. Chappell is the remaining board member who was not here at that time. Ms. Chappell, have you had an opportunity to review the video? And are you prepared to make a vote? All right, then the public hearing has been closed, so I'll solicit a vote on this particular case.
Okay, so I mean, sorry, did you, Ms. David, did you see, Shonda, you haven't seen it, so we're really looking at the 4 of us, so I guess the question is there a motion, on this case and, or a request to open discussion on the case? Or a request, I mean, we can, if you'd like to talk about the case, that's fine. Or if there's a motion, that's fine too.
Is Ms. Sanford wanting to renew the motion that you made on that case? Which
Yes.
is to grant the variance?
I was looking to make sure it was the same case, and yes, I would like to renew my motion that we grant that.
Okay, there is a motion to grant the variance on this case. Is there a second to grant the variance?
I would second it.
There's a motion and there's a second. Any discussion? Okay, all those in favor of granting the variance, raise your hand, say aye. 2, all opposed? Okay, that motion fails 2-3.
So, Mr. Chairman, as you know, when a case fails to receive 4 affirmative votes within 30 days, it's deemed denied by operation of law, which is the situation we're in now. This would be the last opportunity for this case to receive 4 affirmative votes, so this particular case has been deemed denied, and the variance will not be granted.
Okay, and I know that there was some thought on the board on this particular case, offering the applicant, because of the unusual situation of his property, but yet not having a plan that was agreeable to 4 board members in terms of passing this variance, that we allow this applicant to revisit his plan and submit another appeal to this board maybe sooner than the 6 months that's passed, to give him a chance to maybe work with some of his neighbors and consider some of the issues that were raised from this board. And unless there's opposition, I would be willing to allow him, again, with a new plan that maybe addresses some of those concerns, to come back sooner than the 6 months. Does anyone have objection to that? Then if not, then I'll make that as a motion to allow him, should he be willing to reapply sooner than the 6-month timeline.
I will second it.
Okay, we have a motion, we have a second. Any discussion?
What is, how soon can he reapply?
Well, I think he's
Soon as he-
eligible.
Right away.
I think, well, there's a natural timeline in that you have to have notice, and you have to
Sure,
apply, then you have
right.
to have, I think, 30 days notice or some period of time of notice. So as soon as he meets that, but I don't know if the applicant is here, but I hope that if he's not, then he can hear this in the tape proceedings. But I hope it's clear that he knows that he doesn't have the votes on this board now, so he certainly can't just come back with what he had before, and that he really needs to listen to not only his neighbors, but the concerns of the folks that had said no, and that this is an unusual step, in part because I think, at least from my perspective, having voted against the variance, I do think that there's the possibility for him to bring a case to us that we could support, but it needs more homework than what he brought to us the first time. So that's why I think in this case it's worth offering that to him. So all in favor of allowing this, unless there's more discussion, all in favor, say aye. Aye. Any opposed? Okay. So he is eligible to apply whenever he chooses to apply.
Next case for the board to consider is case 2018-644 involving property at 1044A 2nd Avenue South. This is a request for variances from the front and rear setbacks in the R6 district to main 2 already constructed homes. You'll see here the zoning on the zoning map shows R6 as the zoning. Aerial photography giving you a sense of the surrounding area where the houses are. Before you is the site plan of the existing houses. And then finally, the photography showing you the current conditions of the property. Is there anyone here in opposition to case 644? Seeing none, Cleveland Bain is here on behalf of the appellant. You'll have 5 minutes to make your presentation. Please identify yourself by name and address.
Good afternoon. My name's Cleveland Bain. I'm an attorney with the West Nashville Law Group, 4800 Charlotte Avenue. Thank you, Mr. Chairman. Congratulations, Mr. Vice Chairman and members of the board. We thank you for the opportunity to present to you this afternoon. This is a difficult situation that the board has seen previously. Fortunately, we don't see it all the time. I represent Mr. Devin McClish. He is one of the owners of the property. As mentioned, this is an R6 zoning urban infill lot on 2nd Avenue. Prior to construction, the owners and the builders retained the services of a surveyor to come out and pin the corners of the foundation. A lot of times that is something that the general contractor may do himself or one of his subcontractors. However, my clients were attempting to go to the extra step to make sure that they would not have a boundary or setback issue, and they retained the services of a surveyor. It became apparent before Unit A closed that surveyor made a mistake in locating and pinning the corners for the footings. As you can see by the as-built, Unit A is significantly close to the property line, and then Unit A is somewhat built into the side setbacks. This case was set on your agenda on December. I asked for a deferral and then subsequently an indefinite deferral. We've renoticed the neighbors and we're here now. In the meantime, we met with Director, or I had a conference call with Director Herbert and Assistant Director Hall to address the fire safety issues and the life safety issues concerning buildings that are built this close together. Subsequent to that conversation, myself, the owners, their representatives, and architect David Heffley met on site with a lead codes inspector. These are 3-story residential units, and we went floor by floor to identify any and all possible code issues that may arise with the buildings being this close. We also formulated a plan to implement and install additional fireproofing measures that would become code compliant once that they were installed. My clients are fully willing and prepared to make those fireproofing measures.
So what were the issues? So you said you went floor by floor to identify the issues. What specifically were the issues that were identified?
So some of the issues were the fire rating on the walls. The owners are going to have to, in order to become code compliant, we'll have to remove the exterior hardy board sheathing, add a gypsum board that has a higher fire rating. There's going to have to be window replacements that meet the applicable fire rating. They're going to have to do different I think sealing techniques, and sealing, that's my accent, S-E-A-L-I-N-G, in order to prevent air drafts and things like that. We spend a significant amount of time identifying those issues, and the applicant has also retained David Heffley, a licensed AIA architect, to shepherd them through that process. Since that time, the Codes Department has pulled their UNO, so all these fireproofing measures will have to be installed and implemented before another UNO is issued.
And then who owns the property that is most impacted by this?
The most adjacent neighbor is True Development LLC, and a member of that LLC is a gentleman by the name of John Hayes. I think if you look in your packet, you will see that he has submitted a letter to the board supporting air variance and requesting such variance. We've had multiple conversations with him. We've had interplay with him and the Codes Department in order to determine if and what impact this would have on him. I believe my understanding from our last meeting is as long as we do everything that has been instructed to us by the Codes Department, the fireproofing will need to be only on our unit, and that Unit A. There's enough separation between Unit B and his property not to need anything else.
Well, so, I mean, I'll make an assumption. It's owned by an LLC, and whatever was there is torn down, so something's getting ready to be built next door. What is the setback that he's planning to build to next door?
Well, I would believe if he proceeds under his R6 zoning, that's a 5-foot side setback. So I believe at one point in time there was an SP submitted. I don't know the status of that, but I'm just assuming it would be a 5-foot side setback.
Okay. But you don't have any, and he's not here, and no representative from the neighbors here, and you don't have the specific plans on that?
I spoke individually to the neighbor, I guess, to the south. They've been in the property for quite some time. It's not been redeveloped. They said that they were relatively indifferent to the variance, so they were not opposed. I've spoken to the council person. I think that he is not opposed to it. And then, like I said, I've had several conversations with Mr. Hayes. Other than that, we've noticed this, I think, twice now. We haven't had a tremendous amount of neighborhood input one way or the other.
Right. I mean, and we got, I guess this is, because this has been around for a long time, we have two letters of opposition from Colby Sledge, who's a council member, and then we have one letter in January that's neutral, but we haven't gotten anything else from the council member other than what you've said your conversation was with him.
Well, yes, and I take neutral as not opposed. We transitioned from opposed to neutral. I believe, I don't want to speak for the council person, but I believe in our conversations he thought that this was something that the private parties should probably try to work out. And I have forwarded him on conversations, and I've sent him an email letting him know our position and about our conversations with the codes department.
Yeah, do you know, I mean, how difficult would it be to get plans for the, I mean, obviously, I think the fire rating is important, really protecting that side of the property, but it does cause me a little bit, and if we know that neighbor is going to be, the 5-foot setback, then, you're going to be pretty close to 6 feet, which is not unusual for it's not an unusual distance in Nashville for homes to be apart. But the SP part, or just the mystery of what this person may be wanting to propose, does cause me a little bit of pause, because I would like to make sure that there's at least 5 feet, and if we put that condition on it, then that limits your neighbor's ability, perhaps if he was doing an SP, and I just want to make sure that everybody truly is comfortable with this situation.
Well, as you said, Mr. Chairman, it's not uncommon, in Davidson County to see houses, 6 feet apart, depending on, zoning code, you have 3-foot side setbacks. But from my conversations with the codes department and their architect, I feel confident with the fire safety aspect of this. I mean, it's going to be done in coordination with the architect. Everything's going to be closely monitored by the codes department. This is clearly on their radar. As I mentioned before, they've already taken back a UNO that has been issued. So on the fire safety concern, I mean, that's one of the reasons why this has been around for so long, is because we've taken the time and the attention to address the fire safety issues. I mean, we have the zoning issue, obviously, but really the public safety issue of the fireproofing is the impetus here, and that's why the applicants and everyone involved has spent so much time in making sure that is not going to be a concern.
Yeah, and like I said, my issue is really more with getting a guarantee from the next door neighbor that they're not going to ask anything less than 5 feet for however they develop their property.
So I'm going to get you to spoon feed me a little bit here. So the required side setback for both the front unit and the rear unit is 5 feet, correct?
That's correct.
And then on the front unit, you want to go 6 inches?
No.
6, because that's what it was looking like on the application I have.
Back unit 6 inches.
Back-
3.5. 3 feet 3 inches.
Unit A.
3 feet 3 inches for the rear unit. I see that part, but then I'm seeing 6 inches on the front unit.
I think it may be flip-flopped over.
Okay.
I think you may have. I think it's the back. It's the back part of the property that's 6 inches. And so.
No.
What?
No. The front unit A is 0.62, and the way surveyors do it is 0.62, so that's about 7 inches off the property line. That's unit A. Now, unit B, that's the front corner. Unit B, it's about 3.5 feet off the property line. So we're needing approximately 4.5 feet on the front one and a couple feet on the rear one.
So the picture in the upper left-hand corner that we're looking at on the screen, that corner that's right by the red variance sign, that is the one that's closest to the property line, and that is 6 inches from the property line.
That's correct, Mr. Chairman.
Okay.
Does that make sense?
Yeah, and so the hardship is here that the surveyor erred, is that what? Right, is that what I understand?
Yes, Mr. Vice Chairman, I would, and that's what I would submit as far as the board being entitled to giving and my clients being able to receive a variance is under Tennessee Code 137207, which is also reflected in Metro Code 174370, and that's the extraordinary exceptional condition. And that was not something that the applicant did. It was not a hardship that they imposed on themselves. There's no injury to the neighboring property, and I think we talked about that heavily with the fireproofing, and that also coincides with no harm to the public welfare, and in no way.
But was the survey, I didn't mean to interrupt.
Oh, sorry, I was going to get the last one in there.
I'll lose my question if I don't
Yes, sir.
sometimes. The survey was done, though, before you came up with the site plans, correct? Or
Yes.
When did you realize the error in the survey?
No, the error was not realized almost until, it prevented the closing on Unit A. This unit had a contract for sale. Buyers were going through the purchase, and it did not close because of this. And shortly after that is when we were retained. So these were completely built. They were move-in ready before we ever realized that there was this issue.
Got a question. Typical
Yes, ma'am.
process, and I think you may have said it, is that a surveyor would come out and stake the buildings on behalf of a contractor or a property owner. Is that what happened here?
Yes, ma'am.
And that's the surveyor that made the mistake?
Yes, ma'am.
The survey was done, and then the plans were done, and then the units were built, and then you discovered it after that.
Yes, sir. Just briefly, like, a surveyor will come out and survey the lot, usually for boundary lines, setbacks, and things like that. And then the builder or architect will supply them, whomever, with the plans that they would like to build. And then, based on those plans, they'll put the site plan onto the survey, and then the surveyor will then come back out and what they say pin the corners. That'll identify the corners of all the footings and foundations. And then once they pin the corners, then the excavator will come in, dig the footings, pour, and things like that. So it's a multi-step.
Are there any other questions for the applicant?
Well, I guess I have one more. So nobody, during the construction, nobody noticed that it was 6 inches from the other property line? Was the lot next to it vacant?
Yes.
Were the survey stakes in during construction?
No, the survey stakes would have been removed during the excavation part. So once the excavator gets on site to start digging the footers, the stakings are essentially removed because they'll just start digging. And
Right, but the corners would have been staked, correct? The corners of the property, did the corner property survey stakes stay up during construction? I'm just trying to figure out why.
And I think I understand where you're going with it, Mr. Vice Chairman, but the setback from the street there, the minimum setback because of the average of the four next to it is about 23 and a half feet, and then it's a little behind that. So you're talking about over 20 feet so if there was a corner stake and from where the corner of the building was, is approximately 20-something feet. So it wasn't as if there was a line. They don't put a straight line from one corner to the other down the boundary. So you get 20, 25 feet of distance that you have to kind of eyeball. So it wasn't as if they were right beside each other. And there may be an argument that somebody should have seen it, but I don't think that they did because, like I said, when you have a surveyor come out and pin the corners, it's very rare for a excavator or a mason or someone like that to call in question a surveyor's pinnings.
Yes, and so the pinnings would have been wrong anyway, is what you're saying, right? If someone would have noticed, if someone on site would have walked it off, they would have been walking it off on pins that weren't correct because the survey was not correct, correct?
Correct, yeah.
Okay, I follow you.
Yeah, it was.
Okay, I got you, yeah. So it couldn't have been noticed during construction because you had survey stakes and pins in the wrong place.
Yeah, it was wrong from the beginning.
Any other questions? Did you have?
Has anybody taken this up with the surveyor in terms of
My
the
understanding.
problem created here?
That's someone else's hill to climb. I'm just here to get a
Okay.
variance.
You're not aware of it?
That's
All right.
All right. Any other questions for the applicant? Did you have anything else to add?
No, just that last thing. I just want to make sure, like statutorily, we get it all in that that this is not in dereliction of the master plan. So I think all the statutory and the code elements can be met that would enable this body to grant a variance in this situation.
And I'm trying to figure out it, and I don't know how my fellow commissioners feel about this case, but the one hang up that I have still is I appreciate your next door neighbor who is impacted most by this because it's closest to their property, which is the Tree Development LLC. Is that correct?
Yes, sir.
And, where they clearly say they don't have an issue with it, I appreciate it, but there's nowhere that they state that what they plan to do will adhere to the 5-foot setback. And so I'm assuming that if that is a condition of this variance, if the variance is given, that it be conditioned upon that property owner writing a letter saying that we will not build anything or request anything closer than a 5-foot setback, that would be acceptable.
Can I mention one more thing, Mr. Chairman, because maybe this will put your mind at ease? And I understand your concern. When we started this process, we were anticipating fireproofing
Right.
both. That was one of the reasons why we got held up so long since December, is because he had these plans that were in SP. It was hard to determine what, if anything, we were going to have to fireproof. Well, after our on-site visit with Metro Codes and giving the code requirements, and I'm not a code expert, I'm just relying on what they told me, my understanding is that no fireproofing would be needed on True Development's project. It was only going to be on Unit A. So I think I understand the chairman's position, but I don't know if I could submit like an alternative, whether either A, they build 5 feet in the setback, or if for some reason in their SP, they were to build closer than 5 feet, then I believe my clients would be willing to do that additional fireproofing for any affected units of True Developments. Does that make sense? Because I think instead of imposing a setback restriction on True Development, why don't we put the obligation on our clients to fireproof anything, and that would eliminate the safety concern.
Well, that might be something that the board would consider too, but you're also saying if they, it's not uncommon for folks to ask for, an SP with maybe a 3-foot setback, but that just puts that house 3 feet, which is really, really close. And I get that, but like I said, I'm just a lot more comfortable if I knew that they were going to follow base zoning and have a 5-foot setback. And, the comment was that, that we're not sure and it might be an SP, and that makes it a lot more cloudy for me. So I think that your comments are that the board should think about other ways to protect both parties, and I appreciate it. And I just was throwing out one thought, and then we can see what other people think when we get to discussion. But did you have anything else to add?
No, that's it. Thank you, Mr. Chairman.
Were there any more questions for the applicant? And there was no opposition, right? Okay, then we will close the public hearing and discuss the case. Thoughts?
Well, I'm comfortable with it because of all that he's done with the codes department, and I trust the resolution they all came to.
Yeah, and I don't know how, if you all shared the concern I have, but like I said, I feel really uncomfortable about the next door property coming 3 feet. Now, if they are 5 feet, which is what the code says this house should have been, and you end up with almost, at the narrowest point, almost 6 feet, which is not uncommon in some of our HPRs. There's 6 feet between homes is not uncommon. I'm pretty comfortable with it, but I guess there's enough of a mystery of what's there that makes me a little bit wary about it. But I appreciate the architect who is often most concerned about these things and educating us and what it means to have your thoughts. So.
The letter in support we have from True Development says they don't have an opposition as long as it has no adverse effect on their future construction. To me, that says they intend to follow the code, and I think that could be shown to them at a future time. But I'm comfortable with the suggestion that in the event they are seeking a variance, that this landowner is willing to do fireproofing if that's an issue.
So that if I think that was the suggestion of the attorney, if for whatever reason the neighboring property, either through the SP process or the variance process. And again, if it's a variance, they'd have to have a hardship, and it's kind of, that's a little difficult to see on a flat piece of property that's square. But if they were to have that, the burden would be on this property owner to add the additional fire rating necessary for codes to be satisfied. Is there a motion or a thought on, does that evolve into a potential motion?
I'll make it a motion. I move that we grant the variance based on the hardship demonstrated by the faulty survey and the efforts made to rectify the fireproofing in accordance with codes. I don't know how to specifically put in that further this landowner will be responsible should fireproofing be necessary on whatever address that is next door owned by True Development.
If
In the event.
in the event that their
That's necessary.
construction is within 5 feet of their property line.
In which case, they'd have to be seeking a variance anyway.
Right.
Which we.
Or through the SP process is
Or-
what
or through the
that's
process.
the piece I'm most concerned about, is if they get an SP that pushes it much closer, then we've created a situation that might
Yeah.
not address that issue.
I'm agreeable with that amendment, however, the best way to make that is.
I think it's fine, just as stated. I mean, I'll defer to Metro Legal, but from what I heard, it's fine as stated. That's the condition of the variance.
I believe we have a motion that is to approve the variance and based on the bringing this up to the safety standards that have been outlined by the Codes Department in order to get their UNO, and that if the neighboring property requires building into the 5-foot setback through an SP process or other process, that this property owner is responsible for any additional fireproofing to make it safe between those two buildings. Is that?
I'll second your.
Okay, okay. Well, that is the motion that I thought I heard you say, and it has been seconded either by me or by you, depending upon who Jessica writes down as having made that motion. So there is a motion, and it has been seconded. Is there any discussion on the motion?
This is probably too technical, but fireproofing is technically something you spray on a structure. So what they are doing is they need to provide the proper fire-rated construction.
Okay, and we'll accept that as a,
Yeah, I don't know how to fit it in. I just.
no, I think that's fine. It basically it has to satisfy codes for all safety concerns before they get their UNO is the intent of that. And I think that,
I know the intent.
no, that language is appreciated. No, I'm just saying that, so I think add that in to make sure that it's very clear, and that's helpful. Okay, so a motion, there's been a second. Any other discussion? All in favor of the motion, say aye.
Aye.
Any opposed to the motion? The motion passes.
Next case is case 2018-656 involving property at 3509B Renwood Drive. The board may recall this case. This was for a 6-inch variance request due to a garage that was built on an existing foundation. The variance was granted, and after the variance was granted, there was some confusion regarding the council member's position on this particular case, and so therefore there was a request for rehearing that was granted by this board. So this is the actual rehearing of this case. Facts are the same, but I will review them for your knowledge and edification. Zoning map here shows you the zoning of the property is R6. Aerial photography giving you a sense of the surrounding areas. This is the site plan, I believe, showing you where the garage was built. And then finally, the photograph showing you the current conditions of the property as well as up and down the street from this property. There is opposition present for this case. That being the case, Mr. Dillingham, you'll have 10 minutes to make your desired presentation. Remember, if you want to have a rebuttal period, to reserve that from this initial 10 minutes. So you can make your desired presentation to the case regarding this variance request now.
Thank you. Hi, my name is Martin Dillingham, 3509 Renwood Avenue, Nashville, Tennessee. First, I'd like to speak on the matter that led to the rehearing. It was not ever my intent to mislead you guys or to misrepresent the conversation that I had with Ms. Murphy, and that would never be any intent of mine. Excuse me. To review the facts from the case, in the folders that I've given you, you'll find the historic location of the garage and the historic tax records showing that garage was there. This building, as well as the house that's on this property, were both built in 1947. The garage was in terrible condition, and I tore the walls down. It was rotten, and I rebuilt the garage very hastily because I found out that I was having a child, and I needed to just get it done. I do regret having done that in that order. I very much wish that I had gotten the permit ahead of time instead of going backwards, but as Mr. Ewing, who used to be on the board here, said, there are things that are set up to, like fees associated with filing a permit after you do the building.
So the penalty, you paid the penalty for going in the wrong order?
Yeah, I've done all of the permit stuff, and the permit's status is also in that folder that I've given you. It is written on the permit status that it will be finalized with this variance.
So it requires 3 feet, and you're at 2.5, is that, so you're 6 inches
Exactly.
over? Okay.
So I'm 6
And that
inches
was-
over the variance, and this is the historic location of this slab.
Okay, and you built on the slab, as I recall?
Yeah,
Right.
absolutely. So it's the historic foundation, if you will.
And I see you did paint your building the
That was the
color of
one.
the house.
That was the one request that you guys had given me to grant the variance, and it has been painted. You can see the current condition of the garage in the photos that I've given you. Also in that packet, you do see the Google image showing the foundation, as well as a photo that had been submitted in opposition to this case that does show that foundation in those photos as well.
Are there any questions for the applicant? Okay, well, you will have 7 minutes and 39 seconds for rebuttal.
Thank you.
All right. If you would, state your name and tell us your opposition to this case.
Yes, my name is Don Bouchard. I'm at 3511A Renwood Avenue. First of all, I'd like to thank the board for rehearing this case. As far as I'm concerned, I think there just needs to be a little clarification. There was no misunderstanding. I have talked to Ms. Kathleen Murphy, and she stated for the record, I think that's all on record as far as the board was misled. That's the bottom line. What I'd like to do is I submitted a packet that I had just given the young lady over here. I just kind of want to give you a brief idea of what's in the packet so you know what you're going to be looking at. This is the type of thing that we've been going through this entire hearing. By the way, before I even say this, it was never my intent to turn Mr. Dillingham in for the permit issues. I could have cared less. My concern is how close the building was to the property. The only way to do that was to go through that. If it was built in the right area, I could have cared less. Neither me or myself nor my wife. My issue with this is if you look at the first email here, if you flip to the second page, this is the first issue I have. Mr. Dillingham spoke to apparently the building chief and sent an email to, or talked to Corrine West, who emailed my wife saying, the neighbor claims the wooden privacy fence belongs to them. He built it to keep the dog from entering their property. It's completely untrue. We've dealt with falsities through this whole thing, and it didn't stop at the last meeting. That's page number 1. If I go to page number 2, I just want to hit on this briefly. Actually, I'll get back to the text. Page 3, there's a petition. We have 21 signatures from neighbors on both our street and the street behind us, detailing that they were in opposition of this as well. After that, there's a letter from the neighbor. Mr. Dillingham said there were walls up on the property. There were no walls. It was just a cement slab. She just verifies that in the letter. The reason I put this first picture up of this driveway is, and you'll see where it relates. Back months ago, I had asked Mr. Dillingham, we were planning on expanding our driveway. I knew Mr. Dillingham was very protective of his property, so I texted him and asked him for his survey, which means he had a survey of his lot. He told me he would get it and leave it in his mailbox, which he did. I went by his survey to extend my driveway. So the whole point of him not knowing where the lot line was or what he should have needed to do, to me, is irrelevant. He did know where it was because I asked him for the survey. That's how I did my driveway. I made sure I stayed well away from his property line. As far as, basically, we feel there's a couple different reasons that we feel that this variance should not be allowed. Number one, let me just get to my, based on these things, proper procedure was not followed. He built it and then came to you for acceptance or for the variance. Number two, also, and I apologize, in that packet, there's a letter from and it's very hard to find in this area because every time I had somebody come over, I had a landscaper come over, I had a drainage expert come over. Nobody wants to write any type of a letter because they're worried about getting dragged into a lawsuit. I was able to find a landscaper and irrigation specialist, that's also in the letter, where what's happened is he's 2.5 feet from the property. That's where the walls of his building are. But then you have the overhang from the roof, where there are no gutters on it. Now, he's got gutters on the opposite side, but no gutters on my side, which in turn, when it rains, I'm getting drainage into my property. In all honesty, the structure's 6 months old. I know this doesn't have anything to do with the variance or whatnot, but you can already see in the way it was built, there's already issues. I can see the back is buckling. I mean, it is what it is, but to me, the closer his garage is to my property, if anything were to happen to that, I have an issue with that. This last one I can't speak on for sure because I don't know, but to me, it looks like from the height I think you can see in those pictures, I can't tell because I would never go on his property, but I'm believing there's some type of a second floor storage. If I'm correct, that also has to be counted as square footage. So I can't say for sure about that, but I've been told that, but I couldn't find it in codes, so I just didn't know how that worked. So I don't know if there is a second floor, if that would put it over the allowed square footage for an accessory building. Yes.
So the building is 6 inches over. Do you want your neighbor to have to tear that down, tear up the slab, and rebuild it 6 inches? If you let me finish, please.
Here's what I wanted. Here's what I wanted to have.
Can I finish my question?
I apologize.
Do you want him to have to tear this up, tear up the slab, and rebuild it all so it's 6 inches further away from your property?
Yes.
Okay.
And I'm going to say this. One thing that I tried to say the last time, and I don't think I said it clearly, was all he needed to do, just like I did with my driveway, he didn't need to pour or break up that entire slab. If he had poured an extra 6 to 8 inches on the opposite side, it would have cost him a couple $100. He could have built this garage and there would be no issues. It got brought up last time in the first meeting that he'd have to tear up the slab and do this and do that. That never needed to happen. All he had to do was pour that and everything would have been fine.
So would it, we talked, I think you all had mentioned drainage, potential drainage issues. Would it alleviate some of your drainage concerns if he did put a gutter on the side to your property?
I mean, in all honesty, everything, the way the garage is built, the way the gutters are put up, and I'm just speaking for things that I've seen done at the house. I mean, obviously it would probably help. I never know how long anything's going to last. And here's the thing, really, at the end of the day, the reason my wife and I are very frustrated is not only have we given him every courtesy, he's given us none. And the fact that this is an issue. I mean, he could put up a gutter, it could fall down. He may not, that doesn't do me any good. I'd rather have his building away from the property. Somebody mentioned last time, in fact, I believe it was the former, and I apologize if I'm wrong, I believe it was the former head of the board who had said, we have a lot of cases where somebody will come in if the property's 10,000, 20,000. We really have to think about, how much it's going to cost them to knock it down and rebuild it. Mr. Dillingham said in front of you that it was $3,000. If it's a $3,000 building, knock it down, pour the concrete, build another $3,000 building. My issue is this. We've had the backing of our council member this whole time, which wasn't relayed last time. I'll call it what it is. It was lies here last time. We have lies in the email. We have the support of 21 of our neighbors. And is that really the type of message that the board wants to send? That you can just build it, come in and say whatever you want? I mean, because that's actually what happened. We felt like fools the last time we were here because we knew everything that was going on wasn't true, but couldn't verify it because I didn't want to speak for our councilwoman.
Well, I was at the first hearing. I missed the hearing where this board agreed to rehear the case, and was really surprised to see that it back on the docket. But I guess that, I don't recall my thoughts on the case being influenced one way or the other about the council member, because I know she's very active and normally sends a letter and has been completely dark on this one. And so.
It's been completely, I'm sorry, I missed what you said. I just
No,
didn't.
she hasn't sent a letter. She hasn't sent a letter. I think she came and asked to have us rehear it. But that, there's no letter on the record in favor, no letter in opposition, no letter saying there's neutral.
Okay,
I mean,
so
and this is from someone who very regularly expresses those thoughts. And so.
When she came in that day for us for the rehearing, she asked, will this be on record? So I didn't think we needed another letter. I just saw her 2 weeks ago, just happened to see her out. So, I mean, I literally can't believe this is happening again. I will say this. She said it in front of everybody there. She said exactly what happened. I could play the YouTube video if you want me to. That's exactly what was said. So if you need a letter on top of that, I mean, I'm sorry, but that's a little frustrating. I mean,
No, I stand by what I said, and that you're, and I appreciate that what was said at the last hearing. I just have 7 years of history of people responding to cases in a certain way, and this didn't happen the way it normally happens. And so that says to me that, and I have to revisit my own thinking of the last case to say how important was any concept of opposition, neutrality, or support from the council member. And I don't think it played in mine last time because it felt like it was very similar to other cases that we've heard like this, where someone built on a historic slab that was slightly over the setback requirements. And so.
Can you define a historic slab for me?
Well, I think it.
Because it's not in a historic overlay district.
No. A slab that had existed as part of the original house. It may or may not have been a garage at one point in the life of the home. And, as far as the homeowner, and I think in this case it was testified that this was a family home, and, at some point this was my dad's garage, and it was there, and that's just where it always was. And we have had at least more than a handful of those cases in the 7 years I've been on this board. And so it's not, it is a situation where this board may or may not be empathetic with the applicant to say, we understand why you built that. And then we go to your situation is, well, what is the true damage to the neighbor? And there is clearly ill feelings, I mean, I don't want to know that or anything else, but when I see something like this, I just say, there's a lot more going on here, and you've testified that you feel like you've been giving to your neighbor hadn't been giving back. That's, to me, a sign of ill feelings. And what I'm really trying to figure out as a board member is, what is the true damage to your property? And you've mentioned irrigation, and you've mentioned, water, and I think that there are some corrective issues there, but
how about this? I'd be willing to do this. I do not want, because I don't know how he will build it, so I don't want that. I don't want another gutter. I would like some type of irrigation on the ground. I forget what they call it. There's some type of a drain that they can put in. That's what I would like. Because he could put up some sorry, but half-ass, plastic
A
gutters.
French
and-
drain or
Right.
something at the bottom
If
of
I
his
could put-
property
if I
that runs
could-
water from,
Yeah, if
away
I-
from his,
If we could do something like that, I mean, but I'm not, that would be the only thing that would be, I think that's reasonable.
That might be a good suggestion, because, I mean, where I see this thing going is, he's gonna, if he has to tear it down and rebuild it, you may like a lot less what he's gonna put up, because it seems like there's a lot going on here besides, I mean, 6 inches is, that pin is about 6 inches. That's what we're talking about
I
here.
wish, and I understand that, I just wish sometimes, I completely get it, but when it's only 3 feet, and you have to understand how the height of the building, when you walk out into our backyard, I'm sorry, but if 6 inches is going to make it a little better, that's fine. If the only thing I'm going to be able to do here today is get some type of a drainage, now, from what, the pricing I got, they were talking to like somewhere between $1,100 and $1,200. Does that sound roughly, I mean, that's what they were saying. So if we wanted to do something like that, I'm not going to pay for it. I mean, I'm not doing that.
well, and again, that, part of what we're trying to do is figure out, is there a hardship here, and does this person have a right to keep what's there? And if there is potential damage to the neighbor, is there a remedy that we can come up with to help alleviate that? And so I think that's been a really good suggestion, and I think that's something that we should sincerely consider, because I think you have testified to issues that I think are true, and then we as a board have to weigh what is the impact of that, 6 inches on an otherwise legal building, or there would be other issues here.
I'll be honest with you, I'm kind of glad it got to this point. And I mean, don't trust me, the last thing I wanted to do is have to come, not that I didn't want to see you, but the last thing I wanted to have to do is take another day off to come down here. But because of what has happened with all the rain is when we realized we were having the issue. I know everybody here knows the past couple months have been ridiculous, and that's when we started noticing it. So,
What if he put up a gutter, but before he did it, he ran it? I mean, there's not a lot of variation in gutters. I mean, and to me, getting the rain before it even gets on the ground and draining it somewhere, would that be
here's the thing, the only reason is I can't control anything on his property. So I would much rather have the drain on my property so I know what's going on. I think that's reasonable. Here's the thing, at least I'm asking ahead of time. He didn't do that. I didn't have the courtesy.
I just feel like we're spending a lot of time negotiating when we can do this
Right.
as a board.
Okay. Any other questions for is there any other thing that you have to add?
I guess the only other thing I would say is, like I said, if the drainage thing is something that we can do, that's great. But at the end of the day, I feel very comfortable speaking on what Ms. Murphy said. I know what was said here. I know there have been multiple lies about what's been going on here. And the whole reason I had to come back here to begin with is because we were very uncomfortable the first time, because what he said was not true. And I'll just leave it at that.
Okay, great, thank you. Thank you for coming.
I will ask this, just quick. How does that work if, like, you asked about a drainage and stuff like that? What do I do from here if that was something?
The board will take all of that into account and will make a decision on the case, and it may or may not include conditions that have been talked about. But our goal is to try to hear both sides as thoroughly as possible and then make the best decision that we can.
Okay, thank you.
All right, the applicant can return and have 7 minutes and however many seconds Jessica puts on there for rebuttal.
Thank you. First, to revisit Ms. Murphy's position, of course, I was not trying to misrepresent what she had said. Her comments on it at the first time it was being heard were definitely sharp and unforgettable. She took a firm position that because this permit was filed after I built the garage, that the permit should not be there. she did not speak on damages to the neighborhood or a positive impact of me moving this 6 inches in my recollection. And that is what led me to think that she was neutral in the case, because as far as moving this wall 6 inches, she had very little to say. Her main position was based on the permit. That being said, the next thing was the letter being mentioned where I said that he said that I said that the fence was on my property line. I have no recollection of that letter. I've never claimed that his fence was on my property or was my fence. The only fence that I've ever put up on the property is the one in the pictures that he submitted to you that is running down the property line. It's a very simple metal fence. So that is not an issue. As far as the drainage issue that he's speaking of, as he said himself, February was a historic rain month for us in Nashville. Of course, there was some pooling in the backyard there. Historically, the water always, like this, he is on the low side of my property, and the property slopes uphill towards the high side, and the water runs over my property and then historically always ran through the backyard of the house that previously was on his, was not at the location where his property is now. When they built that house, I said, hey, you know, we're gonna have water issues. And so they put one of these drains with a sock in it, down at the bottom of the base of their house, but they did not put any surface drain in that location. So there have been water issues for the last several years there. It has nothing to do with the garage. The same amount of water is still on the same piece of property. The foundation was there on the same footprint, and the water was coming off of that foundation. So the building of this garage or the 6 inches that it's over has no effect on that as well. But if you guys would be satisfied with it, I would put a gutter on the garage, and I would aim that gutter towards the back piece of the property, to the back side of the property where that water could then drain as it has for years. But to ask for me to put a drain that's going down to the front of my property, it would require the gravel driveway be torn out to lay that drain. And as he said, spending, $1,200 to do something like that, to me is a little bit too much.
Any other questions for the applicant? Anything else that you'd like to add?
No, thank you.
All right, at this time, we will close the public hearing and discuss.
I'd like to ask our architect about this drain. I have one in my yard, and I don't know if I'm on a hill, and it's for the obvious reason. We always get lots of rain, or some months we do. What kind of drain is he talking about?
Yeah, I've always been skeptical of these drains myself, but it's something where there's gravel on the ground and water goes down through the gravel and it goes into a perforated pipe and it gets pushed out somewhere else.
Do you think that a gutter is as effective?
I would be more comfortable with a gutter and a downspout that takes the water somewhere that is not the neighbor's property.
To me, the issue is, would we have approved this? I mean, the applicant didn't do what he was supposed to do on the front end. But the question is, would we have approved this variance initially? And I would have. And I think what you've spoken to, Mr. Chairman, is that historically the board would have. So, and then there's a lot of bad blood between the neighbors going back and forth, and our job really is to try to tell who's telling the truth about who said what, and I believe they've all tried to be truthful. I think it's just a situation that's been aggravated, and I don't like the idea of a French drain because I think, one, it would be too expensive, and I think it involves going over into the neighbor's property. So I would be comfortable approving it, and I think with a gutter. And the applicant has agreed to situate the gutter such that the water drains as much as possible away from his neighbor's property.
Is that a motion?
I will make it a motion, sure.
And I will second it.
Okay, we have a motion, we have a second. Any other discussion? Okay, all in favor of granting the variance with that condition, say aye. Aye. Any opposed? It passes unanimously.
Next case, 2019-082, involving property at 2205 11th Avenue North. This is a sidewalk variance request to construct single-family homes without building sidewalks or paying into the fund. Is the appellant here on this particular case? Anthony Eubanks. Please come forward, Mr. Eubanks. Zoning map here shows you the zoning of this property is R6. Aerial photography giving you a sense of the surrounding area. Site plan for the proposed units on the property. And then finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 082? There is opposition to this. Mr. Eubanks, you'll have 10 minutes to make your desired presentation. If you would like to have any rebuttal, please reserve some time from this initial 10 minutes. And identify yourself by name and address for the board, please.
And sir, if you'll press the button that says mic there, and there you go.
My name's Anthony Eubanks. I live at 1401 Lytton Avenue, Nashville, Tennessee, 37216. We are proposing to construct a single-family house there at 2205 11th Avenue North, and we're doing it through the mayor's office, through the bonds fund, and it's for affordable housing. I don't know if if y'all have gotten a letter from the councilman from that area, and they are trying to, of course, you know that the mayor's office announced the other day that they have been granted certain funds to do this. And in order to keep these houses affordable, if we have to add sidewalks and things into them, then the price would just skyrocket. But I'm quite sure that somewhere in the future that they plan to put sidewalks there. But at the time, we're trying to get these houses done and get them up as affordable and as cost-effective as possible.
And Mr. Hastings, the planning department had recommended that we approve this variance and not have you pay into the fund, but that the only condition would be that you would dedicate the right-of-way along the property in case the city decided to spend its own money, its tax money, to put in the sidewalks. And did you not agree? Apparently you disagree with that, or you wouldn't.
No.
Oh, well, you would have been on the consent
No, I
agenda
didn't
if you'd
disagree
agreed
with
to, I
that.
thought.
I had emailed Mr. Eubanks, but did not hear back from him. I presume he didn't receive my email. But
Okay.
I was trying to confirm if he'd gotten consent because I didn't hear back from him. I didn't.
Okay.
Well, I'm
Let's-
sorry, I
consent
must
agenda.
not just.
Okay, well,
not
let me
missed
just
it.
clarify, just and see if you're okay with this, and we can hear from the opposition, and then we'll have all sides of this case. But the planning department recommends that we approve with conditions, and the condition is the applicant shall dedicate the right-of-way along both property frontages to accommodate a future 4-foot grass strip and 5-foot sidewalk should the city decide to put that in.
That
So
is
you- and if you would agree to that, then you've agreed with the planning department recommendations. That would have put it on the consent agenda, but now there is a person in opposition, and so we can hear from this person. But if you agree with that, then you may or may not have anything else to add. I don't know.
Yes, I do agree with that.
Okay.
That was from the beginning, so my understanding from the beginning, but I'm sorry I missed the
Okay.
email. So.
Okay, well, so in that case, then let's, unless you have something to add right now, we'll hear from the opposition, and then you have a chance to come back and then and answer any questions that the opposition may raise.
Yes.
Thank you.
Yes, ma'am.
All right, ma'am, if you just state your name and tell us your
I'm
thoughts on
Rose
this.
Wiseman. I live at 1107 Kellow Street, Nashville. And first of all, I want to thank you for your notification letter to this effect. But my understanding to the letter that I received, that Mr. Eubanks filed an appeal requesting a variance from the sidewalk requirements. And the question is to me, the question was sent to me, should I, as a property owner located 600 feet from the location, approve or oppose to this construction of a single-family house without building sidewalks into the sidewalk fund? And my answer was I oppose. And why I oppose, to my knowledge, however, when whoever purchased a lot should include the cost of the sidewalk and drainage pipes in that cost. And if the purchase of the lot was from the city, then they should be responsible for the cost of the sidewalk and drainage pipes from the street instead of the builder and the buyer. Now, this cost, to my knowledge, should be included by the person who purchased the lot, and that is before the builder and a contractor builds and sell. Now, the builder or the buyer shouldn't be responsible to pay for the sidewalk and the drainage. But I must say, I was in our community group when the sidewalks were purchased in this area, and we had a grant, and we worked with Metro. In my past research and experiences with this type of situation, this is the way I see this and the purchase of the, but what I feel, I said that I would like to also say that address my main reason for opposing is this. In this neighborhood is a lot of senior citizens. Some have wheelchairs and travel on the sidewalks. Others travel with walkers and canes. And for them to walk in the streets is not safe, and it would be most of the time it would be a disaster. Also, we must remember we have a school in the neighborhood, and some of the children walk to school. And walking in the street would not be safe for them either. Nor will other pedestrians who walks on the trail, to the post office that's there in the community, to the library, and the fast food restaurant located in the neighborhood. Above all, the street in this neighborhood are narrow. And now, other point that I would like to say in this community, we started establishing improvements when I started working with the group. One of our main issues were uniformity, and the sidewalks proved and provided that. With the sidewalks, it made it look better community. We even gave the neighbors to plant gardens and flowers and things in the neighborhood to spruce it up to make it look nice. Now they're messing up our neighborhood. Another point I would like to make is when there's a problem in water sewage and the problem occurs from the house to the street, it's the buyer's responsibility to take care of that. But if it occurs from the street to the house, the city takes care of it. Now, I know that from experience because as I was a victim at one time. So in summary, I would like to say, for safety reasons, to me is enough for making sure that a sidewalk is included and required by law for the property of 2205 11th Avenue North by the lot owner, since this will be an affordable house. Therefore, the one purchasing the lot should be responsible and not the builder or the buyer. It would make it harder for the builder if they have to assume the responsibility of paying for the sidewalk and drainage, which is an expensive cost for anyone, whether affordable or not. I hope you will approve the request for sidewalk and drainage for this property at 2205 11th Avenue North. I just wanted to let you know why I oppose it, and I hope that I made the summary correct.
Great, thank you. Thank you for being here.
Can I ask you, have you spoken to your council person? Have you spoken to your council person about your concerns?
I have a problem hearing, and I didn't hear you, and I'm so
Jeff, if
sorry.
you had spoken to your council member Hastings is the council member here, and
I know.
And he actually had sent a letter saying that we should support the variance here because, and I'll tell you, some of these cases are tough because when I look at the picture, the upper left-hand picture, I see a couple of things. One, I see what you described as a street desperately in need of a sidewalk, but I also see a street that desperately needs the city to put that in, not each person, because of the hill and the way it's engineered. It needs a bigger solution than each homeowner. And that's why the planning department has said, hey, this is probably not the best lot for you to, as a homeowner, to take it upon yourself. But when we get ready to, as a city, to put it in, we want you to give the right-of-way to make it a lot easier for us to put in the sidewalk. That's what the planning department has recommended, and your council members recommended that too. But you have expressed, as well as anyone who's come before us lately, about why it's important and the impact of sidewalks on neighborhoods, and we certainly appreciate that. But I just wanted to make sure that you understood a little bit about what we're looking at. It. No one on this board is against sidewalks at all, but it's how to navigate this rule with the planning department and the council members who represent the districts and that type of thing to do the right thing for the neighborhood. And I sure would hope that this street would get a sidewalk sooner rather than later, because it clearly needs one.
Okay, I seemed that it was because of the affordable price too was a big problem, and I figured that because I know when we took on the responsibility, see, I've been there since 1964 in the area, so I've watched the area grow or deteriorate or whatever has happened to us, and that's why I was really concerned. And then after receiving the lovely letter from you asking me my opinion, I felt like that I should be the one to come and give you my opinion of it. So.
Well, I appreciate you doing that.
Okay.
I would like to say that I so appreciate you working to make your community better. I wish we had more people in Nashville like you. Thank you.
Thank you. I try to work with the community in Metro, and as I say, anything I can do, I do. I work with the polls and everything, so I try to do anything I can for the state. Okay. Thank you so much for hearing me.
Oh, sure. All right, well, we will hear again from the applicant.
Thank you.
Just briefly, I agree with everything that Ms. Wiseman has just said, and I think what's lost in all of this is that the permission to grant the Planning Commission right away to build the sidewalks, so that it's not a matter that it's not going to be done. It is going to be done, but just in another way. The Planning Commission has already put those things in place.
Okay, great. Any other questions?
Well, I'm going to ask you to speak to your councilperson, the councilperson who we just spoke of, and see if he will help get a sidewalk for this neighborhood.
Yes, ma'am. That is their intent. The mayor's office as well. That is their intent.
Any other questions? Okay, anything else to add?
No, sir.
Then we will close the public hearing and discuss. I mean, as we said earlier, had we gotten in touch with this applicant, that based on the recommendation for the Planning Commission and the applicants agreeing to that, it would have been on the consent agenda. And so unless anyone has any other discussion or thoughts, I will move that we grant the variance with the conditions outlined by the Planning Department, that the right-of-way for the entire property be given for future sidewalks. Do you have a motion? Have a second? Any discussion? All in favor, say aye. Aye. Any opposed? Motion passes. Good luck.
Thank you.
Next case, 2019-114, involving property at 209C Duke Street, requesting a variance from sidewalk requirements to construct 2 single-family residences without building sidewalks or paying into the fund. Before you now is the zoning map showing the zoning of the property as R6A. Aerial photography giving you a sense of the surrounding area. Photographs showing you the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 114? I see Councilman Davis here. Councilman Davis, would you like to speak to the board regarding this case before we move forward with the hearing?
Good afternoon, board members. Thank you, each and every one of you, for volunteering your time and your busy schedules. Thank you, code staff, for the long hours you do and for our city. Briefly, this is just like the case that we had last week, and we had another one maybe about 4 weeks on the same street. This is a street where the larger development at the end is building the sidewalks for the whole street. And I'd rather the burden be on them, since they're already doing that, and asking for a waiver of the in lieu fee and of the sidewalk, putting it in there. And I'm just asking the board to please consider that.
And I think that the last case that we had on Duke Street, just like this, we granted that variance, but we had a 3-year variance where if the big developer down the street didn't do what they said they were going to do for whatever reason, then this applicant would be responsible for the sidewalks on the property, and I assume that's acceptable.
Oh, yes.
So, I mean, because we assume the developer is going to do what they say, but we just were trying to cover bases in case that didn't happen, and said that if after 3 years the sidewalk requirements haven't been met, then this applicant would be required to either come back to us and ask for a variance or complete the sidewalks as required by code.
I'm fine with that.
Okay. Great, thank you. Any other questions for the councilman? Thank you. All right, if you would state your name and tell us why you're here.
My name is Carla Newman, and I am here to request not to construct or pay into the fund.
And I don't know if you heard what are we talking about with a 3-year?
3-year.
Because I think that, as the councilman said, that it was negotiated to get sidewalks down the whole street. This would impact you, and it would alleviate you of that burden. But since it hasn't been done yet, we will say, hey, if it hasn't happened in 3 years, then you're responsible for that, and you're amenable to that. That's okay. Any questions for the applicant?
I don't have any questions, but I'll point out that the planning staff recommended disapproval because the applicant has the option to contribute in lieu of construction. But I don't know that you noted your hardship.
It's already been, someone has already said they're going to pay for it, that they're going to build the sidewalks.
Well, what prevents you from building it? What is your hardship?
They said that they were going to build it.
So how definite is that Metro is going to build it? Is that the plan here?
The development down the street.
Development down the street.
Yeah, and I mean, Councilman Davis has testified to this on, I think, 2 other cases where there's some project somewhere close by, and I don't know, I can't remember where it is, but it's on the street, and as part of the negotiation for doing that development, they were going to put the code-conforming sidewalk all the way down the street. And so we started to get some of these properties that are impacted by that offer come to us and say, well, wait a minute, we're almost building too soon. If we built a year later, we're going to have the sidewalk because someone else has offered to pay it.
But I understand. But how definite is this?
Well,
do we have a contract? Do we have any kind of, how do we know it ain't going to fall through?
Well, that's why in the last one we had proposed like a 3-year variance that says if after 3 years then they haven't done what they say, then the burden comes right back to the property owner to build the sidewalks.
Ma'am, do you know when is the new developer down the street scheduled to start building? And
I'm not sure the exact date now.
any approximation?
No, not really.
Yeah,
or Councilman Davis. See? Thank you.
Yeah, Councilman, if you could help us with maybe the timeline that you are aware of for when this might happen.
Like all sidewalks, we needed them yesterday. They're already building. I mean, there's stuff going on. I don't know when codes requires them to get their, I know they have to do it before to get their UNA, their use and occupancy permit. And it could be 8 months from now, it could be 7 months from now.
Okay, but it is actively under construction at this point.
Yeah, exactly. It's right next to the, right behind the Piggly Wiggly and Jackson Hewitt on the Duke side, not the Kingston side.
So, and Councilman Davis, so how does this board know for sure they're going to build the sidewalk? Is there a written agreement?
One thing, though, is planning requires them to do a certain amount of frontage.
Right.
And originally, this was discussed, this was 5, maybe 4 years ago. I have to look back at my calendar. One of the requirements was for them to do it the whole connection way because of the size of it, it's about 80 units. They have to do it all the way down from Duke connecting to Sultana and past Sultana, all the way to the end of Duke and then back up. It was about, and I may be wrong with this number. It was over 10 blocks of sidewalk. So in Duke is only like a 6.
But what you're saying is the agreement has definitely been made.
You're saying, but things happen, people get lawyers. So I'm fine with the 3-year clause on there.
I mean,
I think 3 years is kind of long, that's why
I'm fine with 2 or 1, or maybe 2, yeah.
Okay.
Yeah.
I guess my question is, if planning was aware that this developer is going to build it on the entire street, then why did they recommend what they recommended? I guess is what I'm wondering. And then also, what enforcement does codes have if this developer does not build the sidewalk and then the applicant is now left with this? Like, how is that enforced? With respect to planning, I don't, their recommendation does not contemplate that agreement, presumably because it's not a contract that would have been presented to planning to consider. So it may be that they didn't know, it may be that they didn't feel like they could bind a different developer. They're just looking at this particular property to make a recommendation with respect to sidewalks on this property. And with respect to enforcement, this is the kind of thing that once a condition, if a condition is not met by the time it is supposed to be met, then we would likely abate them and take them to give them an opportunity to come into compliance, to come install the sidewalk. And if they didn't, we would either post a stop work order or take them to environmental court. Well, I actually live very close by to this neighborhood that's going through a lot of development, and I will say that sometimes developers make a lot of promises and then things happen that they don't anticipate during construction, and then they don't live up to it. So I will support any motion, but I do think no matter what, that there should be some accountability that the sidewalk either in lieu fee or that it's built.
Well, and that was the goal for the previous motion, was to basically what is the safety net in case in case it doesn't. So, and we can talk about that more in the discussion. But I think the question that brought you back was, is it under construction now? And it is, and the time frame is closer to maybe a year in terms of completion than 3.
I hope so, but like I get to pick. I feel like because my brother's an engineer, I can pick on engineers.
Right.
It's whenever
Right.
It's whenever they get done requiring what they need to do.
But I think that was good clarification, because it did tell us kind of that it's in process, and it's not just on the drawing board, but it's actually being constructed, and that's helpful. Was there anything else from Councilman Davis that people wanted to know?
Thank you, Councilman Davis.
All right, thank you. And was there, did you have anything that you wanted to add?
No.
Okay. Then we will close the public hearing and discuss, and that is the main concern. When we passed the last one on this street, the goal was, to say, and this board may or may not agree, it's a new board, but we don't want the applicant to necessarily have to build something that has already been agreed to, but what happens if they don't? If the developer doesn't? And that's why we put in that case, a 3-year variance, but it sounds like that is too long because of the current construction, and I don't know that we need that, but others may have some thoughts, so.
Well, I agree they shouldn't have to build something that is planned to be built, but I don't agree with not paying into the in lieu fund. That'll help other neighborhoods.
Yeah, I think that I agree with that too. I think that you ought to have to pay into in lieu of fund too. And as far as the time, well, I'll stay out of the time part, because I think you ought to have to pay in.
Well, and I think in part, I think if you're going to end up, if the end result is a compliant sidewalk, we've never said, if I were the next door neighbor and I was going to pay for my next door neighbor's compliant sidewalk, I don't think that we would ever say, well, the next door neighbor should have paid something. They are actually getting a compliant sidewalk, and so I don't know that I'm in agreement with you on that, but because it's a compliant sidewalk. I mean, if it weren't a compliant sidewalk, I do believe you should contribute and pay.
Well, I think if the applicant has to come back, we still have the position, they can ask for the same variance. You know, if no sidewalk is built, they can, at that time, ask for a variance to not build or pay in lieu. And I feel like, given that we may have a sidewalk, it seems premature to ask for the in lieu today on this particular street.
I agree with you on that, especially with the council member's repeated appearances here to tell us that he believes that.
So we have a couple of different thoughts, and does anyone want to try a motion?
I would make a motion that we grant a one-year variance to determine the sidewalk status.
I second.
Okay, we have a motion, we have a second. Is there any discussion? And basically, this is saying that if a year from now the sidewalk is compliant, then there's no variance needed. If the sidewalk is not compliant in 1 year, then they would have to request another variance or produce a compliant sidewalk or pay into the fine.
I was just going to say I support Commissioner Chappelle's motion because I think that strikes a balance between the responsibilities for sidewalks, but also the applicant not having to pay in the event that the sidewalk is built. So I would support that motion.
Okay. Any other questions or comment? Okay, we have a motion, we have a second. All in favor of the motion, raise your hand. Say aye. Aye. All opposed? Okay, that motion passes 4-2.
Thank you.
Next case, 2019-117, involving property at 444 Humphrey Street. This is a variance, well, this is a request regarding the setbacks. I would note one thing for the board. The code staff inadvertently filed this as a variance request. It's actually a special exception request because it's within the UZO, and therefore a special exception is what's required. I would note that the applicant did send notice regarding this request. They also did the board required neighborhood meeting. So all of the special exception requirements with respect to the, I guess, administrative part of it have been satisfied by the applicant. So the request is for a special exception to reduce the street and rear setbacks as well as a variance from the loading space that's required. They originally requested a sidewalk variance, but that has been withdrawn. You'll see the zoning map here shows you the zoning of the property is MUL. This is for a multi-use development in the MUL district. This is the aerial photography showing you the surrounding areas.
And you said that sidewalk variance has been...
Sidewalk request has been withdrawn. So you're only considering the special exception for the setbacks as well as the variance for the loading requirement.
And since that was the only opposition that the council member has, we assume the council member's in support?
That's right. The council member indicated that if the sidewalk variance request was withdrawn, he would support it. So he is in support of it, as will be presented to you by Mr. Cuthbertson. Site plan here showing you the proposed construction. Looks like it might be upside down. Apologies for that, maybe not. Sorry about that. And this is the photography showing you the current conditions of the property. Is there anyone here in opposition to case 117? Seeing none, the appellant will have 5 minutes to make your desired presentation to the board.
Mr. Chairman, members of the board, Dwayne Cuthbertson, 1806 Allison Place. As the staff alluded, we have several elements of relief requested in order to permit a mixed-use addition to an existing building. The requests before you are essentially predicated on a desire to preserve the historic structure on the site. The existing building, as far as we can tell, is at least 130 years old. We're working with Metro Historic to really document this building's history. The records that we can find so far date back to the 1880s. This building was used in some form or fashion in conjunction with the railroad nearby. So the current owner is really motivated to preserve the existing structure as well as some of the uses that are housed in this existing structure. With that preservation in mind, the owner would also like to increase this site's contribution to the artistic community that exists in Wedgwood, Houston, but it's also growing. The addition before you would attempt to do that. It would expand on the programming in this current building. There's an art gallery in there, but there are also several recording studios and programs that take place in the basement. The addition would house additional art studio space as well as residential space, and then provide a small commercial space on that backside, on the north side of the property. The exceptions are to reduce the rear setback from 20 feet to 7.5 feet, and then reduce the side street setback from 10 feet to 2.5 feet. We feel like the reductions in those setbacks are consistent with the older urban fabric of this particular neighborhood. A lot of buildings are constructed up to or very close to streets. In this particular case, the existing building has a pretty tight relationship with the side street as well, so our side street reduction would carry that pattern down the street. The rear setback would be consistent with the new construction that was just completed immediately to our west, the 3-story, 3.5-story townhomes just beside us. And again, we feel like those elements are consistent with that pattern found in the neighborhood. With respect to the variance, we are asking for a variance of the loading dock requirement. We feel like our unique circumstances are present, and they're found in the desire to keep the old historic building, what was a home, and that constrains the ability for us to accommodate the loading space on the back of the property, as well as provide required parking, in addition to the programming that we're asking for in the new building. But we also feel like the loading requirement, the nature of the building that we're trying to construct, its composition and intent to accommodate a variety of smaller uses is kind of nullifies the need to provide a traditional, if you will, a suburban loading dock requirement, or a 10 by 25 space. Most of these uses, if they're going to need deliveries at all that aren't brought to the spaces by themselves, are going to be accommodated by UPS, by Amazon, by FedEx, and other smaller delivery services, and the need for a space that would accommodate effectively a small tractor trailer is just not there. In addition to that—
Sorry, let me interrupt you a second. You're saying loading dock, and then you're saying loading space.
Loading space.
Okay, so what size loading space?
10 by 25.
That's what you're proposing?
No, that's what is required by the addition.
And where is FedEx and all them going to park? Because to be honest, on my way here, I got stuck behind a FedEx truck who was parked in the road. So.
Well, and so that's so that's part of the rationale here is that we are on a corner lot. Both streets are fairly wide and have on-street parking, and I would argue that that's to me that's the side effect of healthy urban neighborhoods, and from time to time you do have the FedEx truck, and I'll admit—
I have the FedEx truck all the time. The FedEx truck blocks my ability to park in the parking lot in my office. But that aside,
and I would argue that—
are you proposing that the FedEx truck park in the street, not on the property?
The FedEx truck is going to park where the FedEx truck parks.
Putting that aside, there is no loading space on the property. You were proposing that loading be done in the street.
So we have a parking area in between the parking spaces that are proposed mid-site, and again, the nature of the spaces are such that if they are going to have deliveries, they're going to be quick in and out deliveries. It's not going to require a truck to come in and be there for an hour or two.
Pull into the property.
So they could effectively pull into the parking area, pause there for 30 minutes, get in and out with their package, and be gone. I think regardless, what will eventually play out is, the FedEx truck, the UPS truck, they're all going to pull right up against the property, put their blinkers on, run in, run out. So we're asking for the variance. Again, in an attempt to, if we were demoing the site, if we were getting rid of this building, I don't think we'd be asking for a variance of the loading space requirement. I think we could accommodate it.
So the loading space is not part of this special exception. It's the street setback and the rear setback and that are part of the special exception, but not the loading space.
That's right. The code requires within the UZO that special exceptions be the request for setback variance, setbacks reductions. So those are the special exception. The variance is only for the loading.
Will you go back to the 3 photographs?
And
Yes, can you orient me, please, on what we see?
Okay, so the top left image is looking west on Humphreys, across the front of the site. The bottom left image is at the intersection of Humphreys and Brown and looking north across the frontage of the site.
And that's porch is the front of the structure you're wanting to keep?
It's correct. That's the side street,
Okay, so I understand.
if you will. And then the image on the right is just looking at the corner of the property, away from the site.
Okay.
Um,
And
I'm sorry.
Did the parcel that was just built on, did you say there were apartments next door?
They're short-term rentals.
Do they have a loading space?
They don't. They're residential, so they weren't required to provide
Is
that.
there an area with a loading space nearby? I'm just curious to.
For them, there's a driveway, but they all lead to garages. As far as I know, there's no designated loading space.
Is there another spot in your immediate area that would be required to have a loading space and had it? I'm just trying to see if that need is met anywhere else.
I guess I'm trying to understand the question. I may be dense here.
No, maybe I'm asking a bad question. Is there another piece of property near this parcel of property that is required to have a loading zone, a 10 by 25 loading zone? My colleague was concerned that you've got FedEx parking in the street,
Sure.
and so I'm wondering if there's another property.
I think the answer to that is yes, yes. You can use an existing building property as it is. If it doesn't provide the loading dock, then it's legal nonconforming. If any of those vacant properties, or I should say when they redevelop, they'll be subject to the same requirement. I would also add, though, that none of those have a house or an old building from the 1880s that they're trying to preserve.
No, I mean, it's a very interesting project that you're working on, and I'm very sympathetic to what you're asking for. I don't know the neighborhood, so I was trying to inquire about that.
It's evolving into a very dense and active neighborhood, and for sure, you can drive down Humphreys on Friday night and Saturday night, and yeah, you can't drive freely from block to block. You have to stop behind Ubers, but to me, that's the cost of a healthy urban neighborhood. It's just a side effect. I will add that we did have our community meeting. We had close to 30 people there, and there was consensus. They were supportive of everything we were requesting. We have had conversations, informal conversations with some of the owners next door, as well as owners in the immediate vicinity, and they've all been supportive. The council members, as you are aware, supportive of our requests as well.
Any other questions for the applicant? Anything else to add?
No, sir.
All right, we will close the public hearing and discuss. Thoughts?
Do we need to maybe talk about these separately as to the special exception and the variance?
Yeah, I think that's fair enough. And
I mean, I think the requirements for a special exception have been met. It sounds like he's done what he needs to do. It does sound like a really interesting space that the community is for, and so I would be willing to, I'm for the special exception, if we want to get that part.
okay, so there's a motion for the special exception. Is there a second?
I'll second.
We have a motion and a second. Any discussion about the special exception? If not, then all those in favor of granting the special exception, please say aye and raise your hand. Any opposed? That passes unanimously. And now let's talk about the loading space variance.
probably, I would defer to the councilman on this if he is aware of the neighborhood and that is not raised a concern for him. It seems to me that it would be appropriate for a variance, and based on the fact that they're trying to preserve a historic structure and that they are unable to have both parking and this loading requirement. That's my thought. What do y'all think?
Yeah, I tend to think, I mean, and this is probably an inappropriate concern for this specific project, but my concern is, you know, boy, I don't want to see the floodgates open on this. But I think that the difference is that this is a fairly unique property with the, you know, Julia Martin Gallery, and I think what they're trying to do is in line with some other very attractive developments in this neighborhood. And so I think because of the historic home and keeping its height structure, that does limit, I think, what they can do below, and you know, instead of having space above and parking below, that home does cause a hardship, and I think in this specific case is acceptable. And but like I said, I don't want it to be a signal to, as we tell, there's no precedent set by necessarily any case, but that would be the worry, and like I said, it's not as applicable here. Any other thoughts on the variance? Is there a motion?
I would make a motion that we grant the variance based on the hardship of the preservation of the historic structure and the limitations that that brings.
And that variance be conditioned on the preservation of the historic structure, and if the plans were to change and that historic structure were to be,
They would be required to come back.
then they would, yeah.
I second.
Now we have a motion, we have a second. Any other discussion? All those in favor say aye and raise your hand. Aye. Any opposed? It passes 5-1. Next case.
Next case is case 2019-121 involving property at 3020 Nolensville Pike. This is a request for a variance from setback and height requirements in order to allow an existing chain link fence around a property. Councilman Freeman is here to speak regarding this case. I'll let you go, and then I'll make the presentation to the board, unless you want me to make the presentation first. Uh-oh. Is this right? Yeah. So before you now is a zoning of the zoning map showing the zoning of the property is CS. Aerial photography giving you a sense of the surrounding area. I believe you can also see in this photography the fence at issue here. Site map showing you the proposed property. And then finally the photographs showing you the current conditions of the property. Is there anyone here in opposition to this particular case? Seeing none, the appellant will have 5 minutes, and Councilman Freeman, you, of course, don't have any limitation on your time.
Thank you, board members. Thank you, Chair, and especially new board chair, Ms. Davis. I've always enjoyed your passionate speeches before council, so hopefully we won't miss those, and you'll bring that to this board. But this all started about 3 years ago, shortly after the election. My goal to limit the expansion of auto-related uses, both retail, used car, and repair. Through that work, I met with the planning staff over and over, and they told me about a small piece of the ordinance, which I believe was just read, and it reads this: in CS districts, in regards to auto-related uses as well as auto sales, chain link fence, barbed wire, razor wire, similar fencing is prohibited within 25 feet of the right-of-way. Fencing or walls within 25 feet of a public right-of-way shall not be more than 36 inches in height. I'd forgotten about that little bit of information as I moved through getting that my ordinance passed. And then I came back to it. I was like, well, let's start working our way through Nolensville Road. I believe you heard a case 2 weeks ago. It was deferred, so I'm here to speak to hopefully get this matter sorted.
Well, and I hope it was passed along that the reason it was deferred in part because we'd heard that you were very interested in bringing properties in your district up to compliance, and we didn't feel it was appropriate for us to just hear these piecemeal, that we really wanted to hear your thoughts and to make sure that applicants understood what options were available to them in terms of protecting their inventory, which we felt like was an important right for a property owner, but yet how do you do that within the code that would also meet some of the goals that we, again, since you weren't here, that we'd heard that you were interested in terms of beautifying the neighborhood and making sure that things were up to code. And we did hear that there were many options from the code staff, but and that was a reason for deferring that one case, was to say let's try to have a more comprehensive approach to some of these cases that you have said you're going to be bringing.
And that's exactly what John Michael said on the conversation after that meeting. He shared that with me.
Okay. Any questions for the councilman? Okay.
I do, actually, I do, because I'm reading the fence ordinance in the zoning code, and you mentioned something about the fence can't be within 25 feet of a public right-of-way. Is a chain link. I'm not reading it in the ordinance. So is that something special for?
It's not in the ordinance that I passed as far as with the auto-related uses and sales proliferation at the anti-clustering bill. This is, I don't have it. I just took a screenshot of it, but it's in the CS code. It's not on the environmental side. It's in the building specific portion of it. And it even got so bad that I had to meet after 3 months of complaining about these fences. I got pushback from the codes department, said this is not a violation. This is not a violation. And so finally I met with Mr. Herbert. I said, Bill, this is in the code. He said, I get it, you're right. But they're looking at it, our inspectors have been looking at it from a environmental standpoint, just the environmental case that we know with junk, trash, debris, et cetera. He said, it's not in that section of the code. It's in the building requirements for the uses. And he's now made them aware. And so going forward, they're supposed to look for those.
So it's related to automobile use?
Just that specific case, automobile repair and use. It's permitted within the CS with conditions DTC South, IWD, IRIG.
Thank you. That clarifies it. Thanks.
Okay. If you all could state your name and tell us why you're here.
My name is Bernie Gray, and I'm the owner of the property at 3020 Nolensville. And I've got with me Brad Isbell, who is the owner of the business, the AMCO transmission business there. And I've got Mr. Michael Smith, who's the president of RG Fence Company, who did the installation of the fence. The fence was put in late 2016 after numerous vehicles been broken into, damaged, items stolen out of the vehicles, and several vehicles themselves were actually stolen from the lot. We've got a number of police reports, backing up some of that, and not all of them were reported. The police recommended that a fence be put up. They said that was the only effective way to stop all the break-ins and damage to vehicles. We contracted with RG Fence to install the fence, and Mr. Smith drew up a plan for it and reviewed it with Mr. Terry Cobb of the Codes Department, and with minor modifications got his approval for the fence. The fence was installed in around November, December of 2016. We got the violation notice late November, and we're requesting a variance to allow the fence. One, based on the fact that it was recommended to us by the police. Number two, we got approval from the Codes Department, from Mr. Cobb. And number three, we need the fence there to, Brad needs it to protect the vehicles that he's servicing in the business. And the business is not a new business. It's been there since roughly 2002, 2001, 2002, somewhere in that time frame.
And So I guess in terms of, a hardship for this is, it sounds like you're really keying in on maybe the permission from the code department. What would keep you, or why would you not install a code permitted fence, which you can do on the property line, but it just can't be chain link? I mean, it could be brick and, we went through, I guess, those options at the last meeting, which you weren't here to hear. But there were several options for a fence, a legal fence. Why is a chain link fence important rather than another type of fence?
I believe the legal fence is 2 or 3 feet tall.
No, you could have let's ask our code folks, if you are there, to tell us what is a legal fence that would be, I guess, 6 feet tall there?
Right, so according to 1716-070W, it talks about physical separations around an automobile display area when it's automobile sales. And it says a solid wall that is no less than 24 inches in height and no more than 36. So the maximum is 3 feet. And then if it's within the right-of-way, it talks about, it specifically says chain link, barbed wire, razor wire, or similar fencing is prohibited within 25 feet of the right-of-way. And that it needs to be solid masonry pillars with wrought iron or other similar.
So I misunderstood then. For some reason I thought that they could have a pillar and wrought iron fence that was higher than 30 inches at the last meeting, but that may not.
The maximum height is 36 inches.
36 inches is the maximum height.
That's right.
Okay.
And there'd be nothing that would stop somebody from going over a 36-inch fence and throwing a rock through the window and breaking into the car, which has happened many times.
Any questions? Well, and that's our dilemma, is how do you protect, allow people to protect their property and still comply. So that's I had the wrong information in my head. I didn't realize that the absolute height was 36. I thought that there was a masonry 30, but you could go higher with a see-through, nicer-looking fence, but that's not the case. So, did you all have anything else to add?
No. And you mentioned that the main case was protecting the vehicles, but also the consideration that we were given approval to put the fence in by the head of the codes department, and did so. And we went ahead and tried to make sure we were code compliant at the time.
I do have a question for the councilman. I mean, what is your position separately as to the height? Are you opposed to a higher fence for these businesses? I mean, 3 feet to me doesn't seem to offer the kind of protection they need for inventory.
My position is we follow the code. It was adopted in 2011 for obvious reasons. I think we should just follow that code. And to the point where they say they got, I'm sorry, that's my initial, I'm sorry. So let me just stop there. I think that we should stick to the 3 feet. I don't think it's incumbent upon the city to to give variances just for someone to protect their property. If you can't maintain your business in the location, then maybe you could move.
And so as to the chain link, you're opposed to chain link anywhere, even if we were in a position to allow it, for example, on the frontage. I mean, I think we have some competing issues here. You know, these gentlemen have businesses to protect and also inventory that they want to show. I mean, that's one reason they are located in that area. So you're opposed, and this is, we're just discussing. Sure. So you want to follow the code both as to height and as to material, period. Okay.
Correct. And the reason why I say that is because there are several of these. I have the highest density of these uses in the city. We found that during the study. That was not the greatest news, but anyway, it is. And so we have some that are just dilapidated fences, and they're grandfathered because they were built prior to 2011. And so there's nothing I can do about that. So I thought, you know what, I'll just fight for, the law was passed in 2011. Let's just fight for that code and move forward.
Okay.
Let me ask you, is it your position that they could protect their property by hiring a 24-hour security system to have someone on the premises? Have you thought about that, or have you discussed that with any of your constituents?
Well, they could, obviously video surveillance is one option, and such like that. But the property abuts to residential to the rear. There's a church right across the street. And, just what are the aesthetics of that are we going to allow, I guess, if you will?
Well, I get the impression this is not the last case we're going to hear in your district.
No, ma'am. We've got quite a few, and I thought we'd test. This was the first one I brought because it took quite a while back and forth with the codes department saying this is part of the law. Yeah. And as I said, I had to end up meeting with Mr. Herbert, and he said, Mike, you're right. This is part of the law. Our codes inspectors are looking at it from an environmental piece. And so this was the first case that I brought forward. I'm surprised that this is actually the second one we're hearing because I brought forth another one, and their complaint was, well, there are other fences along. And I told her, I was like, we're going to get through all of them. I'm going to start at the north end, and we're going to go to the south end. So, yeah, this is for a few more months.
Thank you for being here.
I guess the last, I have a question for the applicant is, what would, in your opinion, be the minimum height needed to protect to keep someone out? Is it, you've testified 36 inches is too low. What is the minimum, in your opinion, that would deter someone from trying to jump a fence?
Maybe let Brad answer that one.
Does that include barbed wire?
No, you're not allowed to have barbed wire. Okay. I'm saying that.
Then I would say 7 feet.
But how tall is the fence you have now?
6.
I thought you had.
It's 7 feet along the road. I don't know if it would help to see we got a picture of the front of the.
And we have had video surveillance for over 10 years. And
our application says the request of variance to allow a 6-foot chain link fence to stay. So, is it a 6-foot fence or a 7-foot fence that's there now?
Do you remember, Mike?
It's 6+3 where there's barbed wire on the back side, but on the front along the sidewalk, since they did not want barbed wire, we did put up 7 feet.
Okay.
With no barbed wire.
Any other questions for the applicant or the councilman? Did you all have anything else to add? Okay, at this time we will close the public hearing and discuss. This is a tough one. I think at the last hearing we recognized that at least in the recent history, there was a need for this. We've had 2 businesses that have come and said, hey, yeah, we've had problems. And yet the code is fairly clear. And, the deferral was really to try to get a bigger picture, a broader picture than a single applicant's need. And, I don't know that I have the expertise, and I throw it always back on the architect to know, what size fence would it take? Is a 36-inch fence too small to keep someone out? Would the hardship of security allow a 4 or 5 foot fence that was up to code and not chain link? I'm not sure really how to handle this one. It's a tough one, and tough in part because they're more down the pike.
Yeah, it is a tough one. I'm kind of uncomfortable with the hardship being a security issue. That really doesn't have to do with the characteristic of the property. It doesn't have to do with the topography or the narrowness. And we do grant variances when there are issues that are created by the characteristics of the property, but this is really the characteristic of security in the area.
Under the extraordinary circumstance clause, would it apply or not? And I appreciate, I mean, and you may believe it doesn't, and I appreciate that. I think that there is a catch-all that says, no, there's something that's unique about this area that would allow it, but it might have to be extraordinary, and this.
There is a catch-all for other extraordinary and exceptional condition of such property, which I take to mean a characteristic of the property, not a characteristic of what goes on, what activity goes on in the property. And then we can also rely on the specific conditions cited are unique to the subject property and generally not prevalent to other properties in the general area. But I think, the security issue probably is not unique to this particular property. So,
I'm sorry, Ross.
no, go ahead.
Well, I do think we've got to consider, or we can consider that this was allowed. I mean, they had permission. They thought they were building what was allowable, and for many years apparently was allowed by code until it was brought to attention that there was another provision that outlawed it. So, I don't necessarily agree that the code is clear in the sense that there was a misunderstanding for quite some time about the kind of fences that were allowable around this type of property. So I think that's a consideration as well. I mean, I think going forward, we understand, but we are going to have several property owners that we've got to address. And if the answer is going to be everybody with a chain link fence has to tear it down, or all of these auto sales places, to me, that just doesn't seem like the right and best answer for these people that thought they were in compliance. But I'm open for suggestions.
Well, we may not have someone else saying that Terry Cobb approved it. If we have someone that just put it up there and didn't even take time to find out anything, that would be a different circumstance to me.
Well, and I agree, although I think that there would be a case then that there's an item A potential there too, that the zoning administrator or the zoning, the code staff erred when they granted that permission, in which case I think the code would be fairly clear that, yeah, they did err, and then what is the remedy? Do you tear it down or not? But I do agree that it seems to want a different solution than completely tear it down or blanket let them stay. I mean, and to me, there should be
I agree with that, but I don't. There's not much middle ground here, because I don't think it is practical for them to have security on site. I can do the math on that, and having somebody there 7 days a week for 8 hours a night. I mean, it doesn't seem practical. And then I also understand that they don't want a fence that you can't. It defeats the purpose if the fence is so. You can't see through it. So that's what I'm trying to figure out. What is the potential middle ground here?
Well, I mean, to me, it was the height. It was the height, and a pillar and wrought iron fence that is 36 inches tall versus a pillar and wrought iron fence that is maybe 5 feet tall. And that's why, I don't agree with let's say whether I agree with the applicant or not, I don't think I would ever feel comfortable approving a 7 foot tall pillar and wrought iron fence. But to me, that's where I think that there is some room for code compliant materials, but yet address the somewhat unique issue, and I don't know how to get to that. And if we can't get to it, then I'm really not sure what to fall back on, whether it's so.
I have a lot of thoughts, but I think you asked about height of a fence and what might be a good height of a fence. And I have a client who wants a 10-foot high fence because people can get over it. If people want to get over something, they're going to get over it. And I think that the chain link fence is going to help because you can maybe get your foot in, and climb up it. I think it's easier to actually climb, but I don't have an answer, but I don't know what a proper height of a fence would be. 3 feet does seem rather like it'd be easier to get over. But the last case we did have, they had a different concern with people putting, with more vandalism from the outside, not people necessarily jumping over the fence. And I believe they mentioned people were stealing cars and somehow, can I ask them one question? If you don't mind?
Any objection? No.
No. So since you've installed the fence and presumably you have a gate and you lock it at night, has anyone been able to steal a car?
No.
None.
There's been one incident in the last 2.5 years, and somebody actually cut through the fence and went in. There was a Red Cross vehicle there that had some kind of a blood separator in it that we understand is used for drug purification or something. So somebody broke into the car. I think, is that correct, Brad?
That is correct, yes. The other thing, when we have a fence, the thieves are going to go somewhere else. They're not, without a fence, they come to my place, they pillage what they can. We've had people sleeping in customers' cars. When I have a fence, all that ended, but I'm sure my neighbors are having the same problem. The ones that don't have a fence, but there are fences in the area.
Okay. Well, we will reclose the public hearing and see if anyone has any thought to help get to a better answer. And if we don't, then I think the question then is there a path toward that? Because it seems like that there is real concern from the board about the express safety and protection of property. And yet there is a code that requires the applicant to, if they were to build a fence, to fence it in a way that I think that we're not convinced would meet that need, or we wouldn't be talking about it still. And so, you know, historically, when we're in a situation like that, we either just decide something that we can all, 4 of us can agree to, or not, and leave it in limbo, but make some type of motion, or we defer it and try to get the parties, for some length of time, to try to get the parties to come up with an acceptable solution, which may or may not be possible in this case. I'm not hearing, I'm not hearing that that's a path, but, that is an option for us to say, go back, propose a fence using materials that are acceptable in the code at a height that you think is appropriate, and then let us evaluate that fence in terms of how much it deviates from the code and how much we're allowing or willing to allow that to happen. Maybe that's what we do, is put the burden back on the applicant to come up with an acceptable solution that is higher than 36 inches with code required materials, and then evaluate that based on that proposal.
Well, I appreciate Councilmember Freeman trying very hard to make that area that is not the best looking area into a better area. That I suppose that I would be less inclined to listen to this applicant if they had just gone out there and willy-nilly built whatever they wanted, but they didn't. They were very thoughtful. They went to codes. I know who Mr. Cobb is. He approved it. They were trying to act legally. They thought they had acted legally. And I guess I'd be more inclined to cut them more slack than somebody that just went out there and threw up anything they wanted to throw up. Let's say they put barbed wire or whatever they wanted, but they didn't. They were, the testimony is that they tried their best to do what they thought was the legal thing to do. So if I were ever going to agree to allow one to continue, I think this would be the case. And I don't know the facts that we're going to hear on other cases, but we will know that when we hear them.
Did you want to make that a motion?
I
to see where
do.
that
I
goes?
would like to grant this variance just based on what I just said.
There's a motion. Is there a second to that motion?
My thought is, and I'm inclined to have a second, my thought is if we're looking for consistency, and I can certainly understand that from the councilman, I just wonder if we think about deferring. Here's what I wonder, and I think I would go sort of more what Mr. Taylor said, which was let the applicant come back to us with maybe a counter proposal. Their fence is currently 7 feet, which seems tall to me, and I wonder if in this case we look at what they might propose otherwise, which would also potentially give the councilman an opportunity, because, how many businesses are we talking about? We're here twice a month.
Probably 15, 20.
Okay. I mean, that's not, to me, 15 properties is not a huge universe that we're dealing with. And so that's sort of my thought. So I'm sorry, Alma, I want to second your motion, but I just sort of feel like it may be better to let them tell us what they can live with, so that we don't set a standard for this road different than maybe where we want to go. That's my thought. I'm sorry, that was a lot of discussion.
So is that a motion?
I would move that we defer the case one meeting for the applicant to understand, based on what we've heard, 7 feet is twice as tall as what is allowed by the code there. Is there a middle ground? And I understand that would require a potential reinstallation, but I just would like to hear what the applicant would have to say in that regard. We can ask them now, I guess, too. If we can reopen the public hearing.
Any objection to that from board members? No. Then we'll open the public hearing and allow the question.
So you understand what we're trying to figure out here. We hear your concerns, absolutely, but we also don't want to set the standard for somebody else coming in and say, well, there's already a 7-foot fence down the road, chain link, and why can't I keep mine? So is there something we can do?
Well, I guess.
Comment there too before you answer, so you can answer both our questions. As I understand that reading of the code, you can have that fence, but it has to be 25 feet back. And this business, that may not help them because they are displaying something, and if it's 25 feet back, maybe no one will even look at it. But talk about that too, please.
Okay. And we looked at options of taking that fence along Nolensville Road and just backing that off 25 feet. And if we do that, the entry into that area, there's no good way to do it because we've got a rolling fence. We'd have to roll the fence, a big fence uphill, and there's no space for it. The option of reducing the height of the fence, I'm an old guy, I'm 71 years old. If it was a 5-foot fence, I could get over it. I could reach up and get over it pretty easily. And I could put a rock through a windshield and steal out radios and stuff like that. 7 foot, I don't think I would try.
Well, and I guess that, to me, the question is what, you can find out from the code staff what the code compliant materials are, but clearly chain link is not allowed in the code. And I understand you have a unique situation that Alma had talked about, but and I think that what the question is, no, you don't want to have to build a new fence, but if you were to build a new fence with code compliant material, what would you do and how high would it be? And I think you've heard resistance about 7 feet, and maybe you want to come back and propose, 6 feet or 5 feet or something different. But that's the kind of thing where I think at least, my sense is that we're understanding that this is not a code compliant fence, and yet we're empathetic to some of the issues that you've talked about. And so rather than us say, today you have to take it down, or today you can keep it, which I don't think the votes are here to do either, the proposal is, which again hasn't passed, is, well, maybe we can propose something different. Your council member may or may not agree with it, because I think he's stated earlier that, no, he'd like for you to take it down. But he may have other opinions on it too, and I think it'd be worth exploring.
May I add something to that? The owner just said that if he tried to put that 25 feet back, the property had a problem and he would not be able to do that. So I heard Mr. Pepper asking, what is the hardship? He may have just introduced a hardship. Just a comment.
I'm sorry, Councilman.
Let's just be quick. These are not display vehicles. These are not for sale vehicles. These are vehicles to be repaired. So that doesn't mean they have to stay on site every night. Where I take my car to get repaired, if they can't lock it up, then I understand that that's on my responsibility, that, I'm assuming responsibility to be left overnight. These are not display vehicles. These are for repair vehicles. And part of the reason they've got that's kind of off, but they've got an outdoor lift in the back of their property. So we've got several issues here. Would I be amiable or to a lower fence possibly? I know there's one further down the road, which I was going to bring later, that is what you were suggesting. It's a no-climb fence. I think it's about 4 feet, and it has the piers at the top. But the fact that I don't see the hardship in there. It's just the fact that these are not display vehicles. These are repair vehicles that they could either be locked up inside, secured in their building, or stored off-site.
Okay. So, thank you.
Can I say something? Am I allowed?
Is it practical to store these off? So how do you respond to that these vehicles don't have to be on the property?
This is a transmission business, and the vehicles come there because they're generally not moving. And to get them off-site, you'd have to tow them back and forth. You can't just drive them somewhere and store them. And they're a lot of times they have to be pushed into the garage to physically get them there. And you also mentioned the not wanting to set a precedent, but I think, again, this is unique because we were given permission to put the fence in.
Right.
And other businesses you run into aren't going to have that situation.
Right. Okay. Once again, we will close the public hearing and see if we can get somewhere any.
Well, I'm not sure that I like the idea of deferral because this is such a close case to me. I'm not sure which way. I'd still want to hear more from other members. I'm not sure which way I would go on this. It's really, I think the interest here balances equally as any case I've heard so far. But I don't know that we're going to, I understand also that I can see where a 4-foot fence is not going to work, and probably a 5-foot fence is not going to work. They probably need at least 6 and probably 7. It is a unique case because I think what they did try to comply with the law. On the other hand, if that's the hardship and then that would fit under this extraordinary and exceptional condition, but that has to do with the condition of the property. And this is a really close case, and if we adhere to the code, then the code talks about characteristics of the property, and I don't see a hardship created by a characteristic of the property. But that's not to say I'm still, to be direct, not sure which way to go on this, and I'd want to hear from other people. I think it's a really close case. If deferral would get us maybe a solution that's workable, then I don't think nobody's going to lose any skin by having a deferral, I don't think. I mean, you'd have to come back, and this is not probably where you want to be on Thursday afternoon again, but so that's where I am.
Well, I take it you're not convinced that the testimony that it would be difficult to build this fence because of the way the property lies, you're not convinced that gives rise to a variance.
Well, that the 25-foot setback is gives rise to a hardship, and maybe I'm not. So kind of tell me, you think that's a hardship because they would?
I guess I'd want to hear more, but I certainly perked up when I heard that in order to try to build this 25 feet back, the property, it just would not work because you could not get into the property. So I was listening to that, but I didn't hear a lot of information. But it's something I would consider.
Did you have any thoughts?
I am with Mr. Pepper that I would like to hear more, but I don't know what more there is to hear. So I think I'm on the side of the deferral, and maybe they come back with a different solution that's more code compliant than what we have now.
Is that,
I would agree with that.
is that a motion?
I would make a motion that we defer
2 meetings?
maybe 2 meetings for the applicant to make a proposal of something that is more code compliant than what you have.
Mike, sorry.
I'll make a motion that we defer 2 meetings for the applicant to come back with a proposal that is more code compliant than what we have. But I also recommend that, to me, I feel like this, especially the height restriction, is an issue for me. I don't speak for my colleagues, and maybe that's something that you can talk about with your constituents in advance of the meeting if you're interested in a more global type of solution to these cases that you're planning on bringing. But that's just my thought.
And when you say 2 meetings, that is the first meeting in May, not we have a specially called meeting next Thursday for short-term rental, but you mean the first meeting in May?
Because I have been talking so much today, I will say that I am out of town the first meeting in May. So some people may not want me here. To the extent people do want me here, I am not here May 2nd.
I am nervous that I may be obligated that afternoon, so there could be some of us missing.
So I guess the question is, next regularly scheduled meeting, which would be the second meeting of April, or 3, and it's your motion. I mean, I don't know what the answer on it is, and I think that hopefully sometimes it just gels with a little bit of thought, and we may just get right back to where we were. But I do think it's fair. But I think you all need to think through, since it is your motion, what meeting you'd like to defer that to, and if it's the second meeting in May, that's, again, I think about your schedule, make the motion, and I think.
I'm going to make a motion that we move this to the second meeting in May. Their fence is compliant. In the meantime, nothing has to happen. It gives you time to make a proposal and speak further with your councilman and maybe your neighbors.
The second,
Board needs a second on that motion.
I will second that.
I will be out of town on the first Thursday in May, and
We're talking about the third Thursday in May.
Third Thursday in May.
That would be May 16th.
Okay, there's a motion, there's a second. All in favor of this motion, say aye. Aye. Any opposed? The motion passes 5-1. And now we will take a 5-minute break.
spoke to them at the break. They are agreeable to those recommendations. So if y'all want to move this to the consent agenda, is there anyone here in opposition to case 130?
And and I think, the conditions, maintain the ADA, close the drive on Edge Hill closest to 12th, and if it is redeveloped or their sidewalks are triggered again, that they would have to comply with the
That's
sidewalk
right, and
laws.
they've agreed to all three of those conditions.
Okay, then I will move that we move case 130 to the consent agenda based on the applicant's willingness to follow planning's recommendations on that case. There's a motion, there's a second. Any discussion? All in favor, say aye. Aye. Any opposed? That motion passes.
So the next case for the board to hear is case 2019-131. This is another sidewalk variance request to construct 2 single-family homes without building sidewalks or paying into the fund. This is involving property at 1525 Preston Drive. Is Jacob Bender here? Mr. Bender, is the appellant here for this case?
If the appellant is not here, this is the first time we've heard this, is that correct?
That's right.
Then I will move that we deferred this case to the next scheduled meeting. The motion has been made and second. Any discussion? All in favor of that, say aye. Aye. Any opposed? That case has been deferred to the next meeting in April.
Next case has...
Next regularly scheduled, not this coming Thursday with the short-term rentals.
April 18th.
April 18th. I'm sorry, next case.
Next case, case 2019-135, involving property at 151A and B Rains Avenue, requesting a variance from sidewalk requirements to construct 2 single-family homes without building sidewalks or paying into the fund. Is there anyone here in opposition to this case? So before you now is the zoning map showing the zoning of the property. It's R6A. Aerial photos giving you a sense of the surrounding areas where the house is. Site plan for the proposed project, and photographs showing you the current conditions of the property as well as up and down the street. Seeing no opposition here, Mr. Cushman, you'll have 5 minutes to make your presentation. Please identify yourself by name and address.
Yes, Rob Cushman, 1019 Avery Trace Circle, which is in Hendersonville. I wanted to present this to you all. There are existing sidewalks on this site. There are new properties to the right and left. There's basically 3 properties in between the new properties that have been built, and those were built prior to the sidewalk changes, so they have the existing sidewalks in front of them. I guess my request is to not have to make the funky jog that this ends up requiring. We have the 4-foot buffer and a 5-foot sidewalk, so what you end up doing is walking down the sidewalk, making a turn, walking down along the 50 feet of your sidewalk, and then back to the existing sidewalk. So I'm happy to build the new sidewalks. It's about $1,000 to build the new sidewalks versus the in lieu of fund or in lieu of fee. I feel like this is more applicable in an area that does not have existing sidewalks. I'm happy to build sidewalks in front of the houses we build that don't have them already. And I'm also happy to bring these into repair if there is, ADA accessibility issues or anything like that. It's just a very simple request to either leave them as they are and bring them into repair, not pay into the fund, or go ahead and build them to meet the new requirements. There was a photo somewhere in the packet as to what it looks like. I don't know if it ended up in the email in your packet, just as to how that jog ends up looking, but I would assume you all have seen how that looks, when it is built. It was emailed over, but may not have made the presentation.
Yeah, no, we do have that, and that is the dilemma of one of the dilemmas of the sidewalk law, especially on a flat piece of property here where it's a lot cheaper to build than to pay.
Sure.
In this, let's see. Are there any questions? Any questions for the applicant? Okay, then did you have anything else to add?
No, sir.
Then we will close the public hearing and discuss case 135.
I would agree that he should build the new sidewalk.
Can you speak up? I'm sorry.
Oh, okay. I didn't realize you couldn't hear me. I would agree that he should build the new sidewalk.
And in other words, and what I was looking for was whether or not he's eligible whether he has to have a variance to, but he doesn't, you just say build a new sidewalk. I mean, there's no
This
variance.
property is
I mean, you're
not
just, you what?
This property's not eligible to pay into the in lieu fund unless the board makes that variance.
Okay, so that's why the request, okay. But if we denied the variance, then he would just have to build a new sidewalk.
That's correct. The ordinance on its face would require them to build the sidewalk here.
Or we could allow him to pay the in lieu fund, but it seemed like that he was more,
Planning had recommended that we be allowed to pay into the fund.
Correct.
I just said it's, from an expense perspective, the bottom line is it doesn't do justice to the neighborhood. I mean, it doesn't look good for a long time.
Right. Okay. Any other thoughts on? Do you have a motion?
okay, I will move that the applicant build the new sidewalk.
That the variance be denied?
The variance be denied, yes. Okay.
Okay. There's a motion, there's a second. Any discussion? All those in favor, raise your hand, say aye. Aye. Opposed? That motion passes, so thank you.
Next case, 2019-137, involving property at 933 Warren Street. Zoning map here shows you the zoning of the property is RS 3.75. Aerial photography giving you a sense of the surrounding area. Proposed site plan for the project. And finally, photos showing you the current conditions of the property. This is a variance request from the side setback requirements in order to construct 2 single-family houses. Is there anyone here in opposition to case 137? Seeing none, Mr. Eubanks, you'll have 5 minutes to make your desired presentation.
Yes. Name's Anthony Eubanks. I live at 1401 Lit Avenue, Nashville, Tennessee, 37216. I was previously in front of the board and about the same property. It had a church, previously a store on it, and we had 2 proposals, one to build 2 single-family houses and to turn the existing building that was there into a coffee shop. So they wanted, the agreement was that once they changed the usage of the property, that we would not come back to change it back to the previous zoning. And so we agreed to that, and the building is being torn down as we speak. And what I am proposing, and y'all did grant me the approval to build 2 single families on here, and then I was informed I needed to come back in order to get some variances on the setbacks. And the only setback that we need a variance on is on the north setback, which is 20 foot, and we're trying to get that reduced to 10 foot. We're going to put 2 21-foot wide buildings on the property, and in between, the minimum distance is 6 foot, and we are requiring to reduce that 20 to 10 in order to where we could get 8 foot in between, so it would make it a little bit better in between the buildings as far as the fire is concerned. And that's basically it.
Do you know if there are other houses on Jackson Street that are 10 feet from the street? I mean, I'm looking at the picture with the old warehouse.
Right. Mm-hmm.
And it seems like that whatever is behind that looks fairly close to the street. And
right.
And I know this is kind of a little bit historic and a little bit transitioning neighborhood. Right. I can see some older houses, but I can also see a lot of new.
Right.
And so I guess I'm really curious to know.
If you look at the one at the bottom left there, the 2-story right there on the corner, it might be less than 10 foot.
But that's on Warren Street, though, isn't it? Isn't that side?
Yeah, that's on Warren Street. The other one is on 10. The setback that I'm referring to is on Jackson Street. If you turn around and look at the other corner, it's one on the other side, and it's pretty close to the sidewalk. Now, all the other setbacks will remain the same. That is the only one that we're requesting to be reduced to 10 foot.
And what is your hardship here, Mr. Eubanks?
Is that we're trying to get two decent-sized buildings on that lot. With this 22 wide by 50, that will give us a nice size single-family home that will venture up to around 2,000 square foot.
Mr. Eubanks, did you consider designs that would fit within the existing setback?
Beg your pardon?
Did you consider designs for these homes that fit within the existing setbacks?
Well, yes. Well, we tried, but if we did that, then you'd be talking about 20. If you went with the minimum, you'd be talking about 29 foot of space that would be taken away, and then you're talking about buildings that might be somewhere around 16 foot wide, little bitty narrow buildings. But 22 foot is pretty reasonable size. If you look at that up on the screen up there, the one that was across the street from it, it's somewhere in that neighborhood, a lot of them, and some of them are even wider. So we're trying to at least give the buyer, to live in these houses, a reasonable square footage.
And do we have any overhead neighborhoody kind of things just to see?
This is the only aerial we have.
Right.
Okay.
So you got quite a few buildings there. A lot of them they're nice sized buildings, anywhere from 2,000 square foot. Some of them might be even bigger, more square footage than 2,000. So we're trying to put something in there that would fit in there and be conducive to the neighborhood.
Any other questions? Is there anything else that you have to add or like to add?
No, sir.
I think we probably should ask him. We probably should ask him if he's willing to comply with what the planning department has recommended.
Do they
Am I on the wrong case?
Yeah, I think so.
Okay. Oh, I'm sorry. I need to move down some. I don't have a screen here. So
Well,
I'm
that's true,
kind of
yeah.
working with a handicap.
This side of the room is at a disadvantage because the screens aren't working on this side of the room, so they have to look behind us or actually look on the different packet. So
Sorry.
No, it's a lot more confusing for you all.
Well, I could add one thing that was kind of cleared up. When I was here previously, it was recommended for me to come back to get the setbacks changed.
Right. Well, and that because there's just two separate questions. One was, do you have a right to have, because you had the different buildings on your property, to have two places and then two residences, and once you decided what the layout would be, then you'd have to come and decide. And then but that's a whole separate, different criteria. So, did you meet the hardship, and what would that be, and that type of thing. So, if there are no other questions, we'll close the public hearing and discuss.
Well, I'll say I don't know the circumstances as to why, and it seems like it was a non-conforming use was granted. I wasn't here for that meeting. So when I look at it, I just see a lot that's 65 feet wide, so I don't see a narrow lot. But for some reason I can't speak to we granted him to be able to have two homes on the lot.
Yeah, there was a commercial structure, and which could remain, and I think that it wasn't necessarily a compromise, but the structure could have stayed and maintained its commercial status, and we said, well, instead we will allow you to kind of have a grandfather to residences as long as you build residences, and but we said, you'd have to, if you comply with codes, and great, you don't have to come back, but if you can't, then you come back and ask for variance. We're not giving you any variances, just the ability to build two homes. And to me, the only thing on some of these is, it's a side variance, and the 20 foot, I think, is because of the nature of the street. but in kind of some of these historic streets, and it is a 65-foot lot, but 45 would be buildable with the 20-foot setback, right? Well, actually, it ends up being a little bit narrow that way. But when I look at this building kind of in the lower left by the J in Jackson, that's really close to the street, and I think, well, do you have kind of historic structures that aren't in that 20-foot setback, and is this really kind of more in keeping with the natural rhythm that's there? But yet it's also transitioning. There's clearly houses that have been built recently, because you can see tall and skinny, and that there are two houses on old lots that have been built. So, and yet you're right, the hardship, how do you build two houses within the footprint? You connect them, flip them, do whatever.
Yeah, it's possible to build them 20 feet wide. I actually live in a house that's 20 feet wide, so I know that's doable. Instead of having the 8 foot between the homes, you could have 6 feet, but I appreciate he's trying to make them just a little better. I appreciate that. I'm just struggling to find the hardship.
The hardship too, in a 10-foot reduction of the setback by 10 feet, if it was 1 foot or 2 foot, then, but 10 feet, and I just don't see the hardship, so.
Any other? Does that equate to a motion?
I will move to deny the variance.
I'll second that, but I'd like to see, I think other board members have comments.
Well, I haven't decided yet. It's not a case where we have opposition. I do remember the hearing in January. It doesn't appear to be inconsistent from what I can tell with the other houses on the street. Is it better to suggest that he build 2 smaller homes, or is it better to grant a variance and allow uniform size homes there? He's also putting 8 feet in between where he only would have to put 2. So,
6.
Excuse me. Yes, a difference of 2 feet there. So we could go a smaller variance, or consider maybe a smaller variance on the side setback, but it's going to put those houses together. I sort of tend to think it's overall an improvement to the neighborhood, but I would have to say that I don't know that there's necessarily a stated hardship that I can see.
I agree with the other comments about I can't really see the hardship here. And then also I am concerned, without seeing what the setbacks are, neighborhoods are all about setbacks and houses being sort of having some form of uniformity. And so without seeing, I know it's a transitional area, but without knowing what the setbacks are for the surrounding context, it's sort of hard for me to say yeah.
Would you prefer, would it be fair to give the applicant a deferral to say, hey, come back with us and tell us, you want to see a 4-block stretch of Jackson Street and know what the setbacks are and how this would impact the whole street? And that would be easy for the applicant to do. And it would give us a better context to know, does this...
That's fine. I'll withdraw my motion if you want to make that a motion.
Yeah, I would support that motion. So I guess I'm moving that we defer this and give the applicant time to give us more context about the surrounding neighborhood and what the setbacks are for Jackson Street within a 4-block radius.
Second.
So what that means is that we don't have enough information now. I think you've testified, but we don't actually see it on the screen. And so going 2 blocks one direction on Jackson, 2 blocks the other direction on Jackson, tell us what the side setbacks are, how the houses are in terms of closeness to the street. Okay. If you look at the J in Jackson here, there's a building there. It looks like 2 houses that are right behind that, but we can't see those houses and we don't have that information, and so we're not. I think that at this point we don't see the hardship, and so we want you to help us, and it will help you if you help us, and so we're deferring this for 2 weeks. That's the motion, and we will vote on it in a minute. But you need to, and you can work with the codes folks to get that information if you have trouble getting it. But basically, come back to us and say, here's why 10 feet makes sense, or 12 feet, which is what Ms. Chappell had suggested might be another distance too.
If you look at the building that's previously on the lot
Right.
there, and if you look across the alley there on Jackson Street, that house is right on the sidewalk.
Right. Well, that absolutely helps your case. But what my fellow commissioners have said is that one point isn't enough. Go a little bit further out. Go a couple blocks in each direction out, and so we can just see the whole picture of what that means. And if that supports your case, as if I think it may, then we'll be in a much better position to come to some other solution than just a flat denial based on a lack of hardship. So I do have a motion.
Could I ask you one more question? Do I have to go back through the process again of sending out all the letters?
That's why we're deferring it. We defer it so that that is the easiest and best solution for this to continue, and you to provide that little bit of information for us to be able to decide more thoroughly. So it just means in 2 weeks you come back, but let's make this official by having a motion and a second, which we have. Any discussion? All in favor of the motion to defer to the next 18th of April? Okay. That passes. So you'll just come back the 18th of April, but come back with that information that we've asked for, which is 2 blocks either direction, how far each house, each side setback is to Jackson Street.
Okay.
Awesome. Thank you.
All right.
Next case.
Next case for the board to consider is case 2019-140 involving property at 2027 Hutton Drive, requesting variances from setback and house orientation requirements in order to construct 2 single-family homes. Is there anyone here in opposition to case 140? There is. Before you now, you'll see the zoning map showing you the zoning of the property is R6. Aerial photography showing you this particular parcel as well as the surrounding areas. This is the proposed site plan that was submitted by the applicant. And then finally, the photograph showing you the current conditions of the property as well as across the street. Seeing that there's opposition here, the appellant will have 10 minutes to make your desired presentation. If you'd like to have a rebuttal period, make sure you reserve that from the initial 10 minutes, and then please identify yourself by name and address.
Yes, ma'am. Good afternoon, Board. This is Paula Hepp, OHM Advisors, 209 10th Avenue South, and Scott Story is also with OHM Advisors, 209 10th Avenue South. We're working with the developer on this property and just wanted to make a couple of statements. The neighborhood is seeing expanded growth through the HPR planning tool. I know you've seen many cases today of that, which is the typical 2 single-family homes in an infill HPR condition. The existing home that's there was on the lot, and it was tilted to face the corner, not one side or the other, Hutton or Rosemary. So what we're asking in this situation is that the parcel that we have is a corner lot, and it's a unique parcel that forms basically a square in essence. The way this property, the subdivision was platted, typically lots are, their width to length ratio is 2 or 3 to 1 times the width, and these corners tend to be more square, so it's harder to develop, if you want to say it that way, in that HPR condition. What we have right now is the if I can find this one, here it is. The developer did not want to do the typical tall and skinnies, as they say nowadays, the tall and skinnies on the property. He looked at this corner and this squared condition and has created 2 separate homes, and the one that is truly on the corner, he's created it with a wraparound porch to show that corner condition and have the homes separated. The ordinance requirements talk about Hutton being the main street. He wanted to separate and have one house go one way and one house go the other way so that it wasn't that whole tall, skinny condition. He wanted to create a really decent development here with this HPR. What's happened is this corner has, because of the squareness of the corner, doesn't lend itself to the codes and the planning tools as well. Right now, if you looked at the homes that are on Rosemary and Hutton, the lengths of those subdivision lots are very long, and what's happened is these homes have been constructed basically in the middle of those lots where you have equidistant rear yard and front yard. When you get to this corner, it becomes cramped down, and we can't seem to fit into that distance of 57-foot street setback with the contextual. The platted subdivision is 30 feet, and we can slide the lots or the homes back some to help meet that requirement, but we can't get to the 57 feet without making those properties very, very, very small and reducing the square footage of the homes. The other thing that the developer was trying to do was trying to give more rear yard for a family condition where you have more of a backyard for the kids to play in than pushing everything to the front street setback side.
Have you all had a chance to talk to Councilmember Sledge?
I did give Councilmember Sledge a call, left him a couple messages. Have not returned any. He's not returned any messages to me this time.
Okay. Yeah, we did get an email from him asking us to defer the case at least one meeting so he can talk with you all, because he said he hadn't had a chance to talk to you, and I just wanted to see if if you all had talked. So you haven't.
No, he has not made
But
contact with us.
But I would like, since we've heard from you, to hear what else you have to say and hear from the opposition. Anybody that has come and spent this much time, I think, deserves a chance to say what they're here. But it may mean also that the board may want to consider the council members' request too. But I'm sorry, continue, please.
No, that was basically it. The developer has looked at the corner and tried to make it as the best potential development that he can. We did see the letter in the packet about the opposition letter, and the trees was one of the things that was brought up, and we wanted to make sure that you knew that the couple of trees in the center of the lot were the only ones that he was attempting to remove to put these two homes in. The rest of the trees are within the setbacks currently on the corner, and he's wanting to keep those.
Any questions for the applicant? Okay, you'll have 5 minutes and 31 seconds for rebuttal, and we will hear from the opposition.
Thank you.
If you would state your name and tell us why you're here.
I'm Gail Ravy. I'm the property owner at next door at 2025 Hutton Drive.
So if you see on this picture, which house is your house?
There's the corner house that they're talking about that's at the corner.
Yes, ma'am.
Mine is right in the center. And then there's another one that was supposed to be up for discussion today for a property for single variance to settle two houses on it. So I came for both of them because I'm right in the middle of both of them.
Oh, so yours is the kind of little blue roof, it looks like?
Yes, ma'am. Yes, sir.
That one?
With the driveway right there.
Okay.
Yes, I'm kind of sitting right in the center.
Okay, so tell me your thoughts.
I have questions, and I've never done this before, so I had to write it down and make sure I'm right. Okay, the one over on the corner, if they're making two houses or variants of that, it's supposed to be 30 miles an hour on the street, but we have people that use the Hutton Drive as a cutoff from Nolensville Road to Glen Rose. They come down at 35, 40 miles an hour. We have kids that play in the street. Right now, with the house on the corner, you can see around the corner. So if there's any kids, dogs, or whatever, either on Hutton or Rosemary, you have a clear view to don't drive fast, to stop. My concern with the variance, because I don't know what variance you're talking about, is it going to cause a problem with people seeing? Because I come around the other side of the street when I'm coming from work, and I've almost, if I weren't going slow, could have nailed a kid. And that was with this side of the street. It's kind of a hard curve, and there's a stop sign, so it's hard to see if you're coming from this side of the street. My concern is on the other side of the street, is it going to block people seeing down the street? Because it's small, as you can see, it's a small, narrow street. And if people are parked on this side, or if they're coming real fast, the kids are going to be nailed, and that's my concern for that house.
Okay, and I don't know, we don't have anything about what the house looks like. All we have is a site plan, which I think was shown on the screen, but from our information, the house will be 30 feet from the street at Hutton and 30 feet from the street at Rosemary.
Okay.
And that's what they're requesting. They're requesting, and I think there's.
Yeah, because I've never talked with them. I've never had any communication with them except the letter that I got in the mail for the other house. I never got a letter in the mail for this house, but for the other house.
Well, and since both of, ma'am, let me just ask you this, because the council member had asked for one meeting deferral to talk with you, and the neighbors, the first time they've seen the site plan, do you have any opposition to a one meeting deferral so that you can fill in your neighbor, so that at least the neighbor will be more informed, and it might end up supporting it, or might continue to oppose it, but have accurate information and reasons to suppose it. So you're okay with the deferral? With that, I'll move that we defer this case until the 18th of April.
Excuse me, can we do one, can I have for 2 weeks maybe? Because I'm working and I got off work today.
Yes, ma'am, it's 2 weeks.
2 weeks, I thought you said a week.
No, one meeting, which would be 2 weeks.
Okay, I heard the one, okay.
2 weeks from today, the 18th of April.
Okay, I heard the one, so that was the reason I was going 1 week in my brain.
I'm sorry, if I may have misspoke, I apologize for that, but I will move that we defer this to give the applicant time to talk to the council member and to fully inform the neighbor of what is going on.
A second.
Got a motion, have a second. Any discussion? All in favor of the motion, say aye. Any opposed? Okay, we will hear this on the 18th of April, and that'll give you all a chance to talk to the neighbors, and then please do your best to continue to get in touch with Councilmember Sledge.
Absolutely.
And I know you said you tried, and hopefully that'll give you a chance to do that.
And I'll get your information, we can talk, okay?
Yeah, because I need to look at it.
We are now ready to move on to the short-term rental portion of the docket, starting with case 2019-065.
Wow.
Involving property at 1105B North 8th Street, requesting an item A appeal challenging the denial of a permit due to operation after a change in ownership. Is there anyone here in opposition to case 2019-065? Seeing no opposition, the appellant will have 5 minutes to make your desired presentation. Mr. McBroom is here on behalf of staff to make staff's presentation.
All right, if you could tell us your name and, I'm sorry, we need to hear from staff first, right? So let's hear, if we can hear, all right, Mac, you got this. Tell us why we're here.
1105B North 8th Street, advertising and operating after the permit was canceled due to an ownership change. On 11/2/18, the ownership change occurred, and there were 3 documented stays that occurred after the permit was canceled due to the ownership change. On the applicant's statement for the appeal, it said that the new owner had, or the previous permit holder had continued to operate, apparently without the knowledge of the the applicant. However, it happens that he was listed on the advertisement as of March 21st as assisting in the hosting duties. There were no documented complaints on this property and no other actions taken 3 days after the permit was canceled due to the ownership change.
And this is a place where an LLC can operate a permit?
I do not have that before me. An LLC can, can operate in a type 3, I mean in a multifamily zoning. Give me a moment, I think I have that.
And while Mr. McBroom's looking that up, Mr. Chairman, I would, of course, remind you that SP zoning districts are uniquely administered by the Planning Department, and they provide the recommendation to staff at the Codes Department as to whether or not a short-term rental permit is something that's allowable under the terms of the specific SP at issue.
Okay, yeah, I didn't see, I guess it said here, I didn't see on the docket that it said SP. I just saw the 8th Avenue. Oh, it sure is right there. Thank you. As much as I thought these reading glasses were going to help me, they sure didn't in that case. Okay. So if you can tell us why you're here.
Sure. My name is Zare Hukowski, and I live at 1105 North 8th Street in Nashville. And the reason I'm here is to ask for a variance for the Airbnb permit. And a little bit of background, I did purchase the property in November of 2018. The tenants, the previous owners, decided to stay there or asked to stay there between November and December, so they didn't have to move through during the holiday season, so they leased it back from me. During that time, they did have an active permit, or prior to that, they did have an active permit to run an Airbnb. They did have some bookings that were there in November. I went in at December, trying to get the permit, doing the right thing, trying to get the permit under my name. When I went to the city and they discovered that, the permit did not transfer to me or there's no grace period, I went in good faith trying to get the permit listed under my name. So at that point, that's when I discovered that I was in violation. Prior to that, I didn't know that I was in violation. It was in somewhere around the 21st of December, I think. I finally got the grant deed. I was able to collect all the evidence that I needed to present to the city to get my permit. And that's when I discovered that the Airbnb permit was revoked because of the change of ownership. I did eventually move in the beginning of January. Well, we had canceled the bookings after December. Once we found out.
Did you rent, when you said that your tenants lived there in November and December, and they used to own the house, right? I guess you bought the house from them?
Correct, and they leased it back from me.
And they stayed for 2 months, and they rented the house Airbnb during that time. Did you get any money for the time, for when they Airbnb'd the house? Did you get any money for that?
That was part of the contractual agreement, that it was to get a portion of those funds.
Okay. And you're just saying that you didn't realize that you had to have a permit, or tell me what? Because it sounds like you were participating in.
They were operating an Airbnb based on the previous operations that they had before, because they had it, I think, a little over a year. So when I purchased the property, they continued to operate the way they had been. This was a rear apartment that they had Airbnb, not their main house. So when I went to the city to get my permit applied for, that's when I discovered that it was revoked, and I was in violation. Prior to that, I didn't know that. So that's why we're here today. I will say that, there hasn't been any impact to the city financially. They've paid all the dues and fees that they needed to pay. It was a valid permit that just expired in February. And as soon as we found out in December, we canceled all the bookings that we could. There were some last minute things in December that people had already booked months in advance that it would have been harmful for everybody if they just automatically said, well, you can't come. So I think they continued some bookings between November and December. But then as soon as we found out that it was a violation, we ceased that. And then since January, there hasn't been any Airbnb listings. And I know the gentleman just said that on March 1st, I was still listed as an Airbnb host or guest. I don't know. I do have an active account, but that house is not active for me, and it's not active for the previous owners either. And I also, just to add, I do know that they have other properties that they are Airbnb-ing out of state, so that's why their account is still active.
I did not understand that. I'm sorry, what now?
In the Airbnb application, you have multiple properties under your account. So if they have an account with 5 properties, all 5 properties will show. And I think that might have been what he was referring to in listing me as part of the owners.
Okay. Any?
Councilman Davis is here. I don't know if he wants to address the board on this one. This is in his district.
Good afternoon, Commissioners. Sorry, good afternoon, Commissioners. I knew the previous residents, Dawn and her husband. Dawn's husband was a dentist, just like my dad. One thing about this circumstance, it's legal for the dadoos, the small apartments. You know, in McFerrin and most in Cleveland Park, we have that accessory. The SP was done, I was a sponsor of it, to allow the 700 square foot dadoos no taller than the roof pitch of your front house. And it has to be 700 square feet, or maybe 750, I'm not sure, I don't have it right in front of me. But the majority of these are one bedroom, one baths. And so when we were doing the original legislation to modifying the Airbnb legislation, we left the dadoos alone because, number one, they're small, one bedroom, majority of them, no more than 750 square feet. It's pretty hard to throw a wild party. Plus, the owner of the property has to be living on the property. And just like this gentleman, he bought the front house. He lives in the front house where Dawn and her husband used to live. And then there was Dawn and her husband didn't want to move during Christmas and were living in their Airbnb house originally, that small dadu, while he was living in the front house. And so, because he is the owner that's living in the front house, I'm in support of him having the same privileges that every dadu owner that has. If the homeowner is living on the property, which he does, he's living in the bigger house in front. And so I have no issue with him or his neighbors, because all of his neighbors do the same thing, leasing out their in-law suites to Airbnb or to whomever, through another service. But whatever he can do to get in compliance and allow him the same privileges, misunderstanding, ask for mercy and a reasonable response. Thank you for your support and all the work y'all do.
All right, thank you.
Thank you.
Did you have anything else to add?
Nope, I'm just here to ask for, the approval of the Airbnb permit and the grant of variance. It's been since January till today, since, I've operated, not operated the Airbnb, so it's been a financial impact for me as well. As I know we're all trying to, make a little extra in these times, so.
Great. And what is Mad Properties LLC?
That is the LLC that the previous owners purchased the property for, and it was grandfathered in because prior to the law going in about no LLCs being allowed to own or operate Airbnbs, so they were grandfathered in from what I understand.
But
and I believe
they're not on our docket. It has Mad Properties LLC as the owner of the property. So do they own the property now?
No, they do not. The grantee granted it to me, but they do own the note. They do hold the note.
The document, the deed, has not been recorded with the property assessor. Apparently, there is some issue with that, and it would probably behoove the new owner to look into that with his title company, but we weren't able to discern exactly what the cause was. It just simply has not been recorded.
So I guess from a codes perspective or a metro legal perspective, according to the city and county, who owns this property?
The owner of record is typically identified through the Register of Deeds, and if the deed's not been properly recorded as to a recent transaction, then the Mad Properties LLC that the appellant talked about would likely identify as the current owner of record. Do not have any question that there was a transaction as described, just a matter of having it properly recorded. Once that is squared away, and having a document to show us is great, but having it recorded with the proper legal entity is even better, of course. Once we've got that record in front of us, it's easier for our staff to process the application accordingly. And of course, here for the board today, today, the good news for the board is you're determining what to do about the appeal and not having to worry about the eligibility for a permit on the back end. Our staff is paid better than you are to figure that out.
Well, they're actually paid. We're volunteers.
May I add, I do have a copy of the recorded warranty deed as well, transferring the property from Mad Properties to myself.
Yeah, if that hasn't already been submitted, that you can, is that
Yeah, I'd like
what
to
this
submit
is?
that for the record.
So did you have anything else? Is that, you didn't have anything else to add at this point?
No, not at the moment.
Okay, I'm going to close the public hearing. And
We were aware of that document. It still has to be recorded. There's some issue that is preventing it from being recorded.
okay, and that I think that's the question for Mr. Poole, the legal staff too. What, it seems like that we're here in part because I guess I'm not sure 100% at all why we're here.
Well, based on the information that we have and the document that the appellant just passed around, there was a transfer of ownership. Once it came to our attention that the ownership had transferred, we sent a notice advising him that I guess, I don't know if he came in to apply, but either way, the transfer of ownership had effectively killed the permit. He had been operating after that transfer of ownership, or someone had been operating after that transfer of ownership with his permission. Therefore, because the transfer of ownership nullified the permit, they were operating without a valid permit, so we denied it. So there was a transfer of ownership, but he's appealing our denial for operation after that transfer of ownership.
Okay, yeah, that's really what I mean, that's ultimately what I was getting at, is what is the offense by which we are judging this, because
operating basically without a permit.
Operating without a permit.
That's right.
And should he be eligible? Yeah, that's where, because all this says is he rented after it was revoked because of the ownership change, and so, but what we're really saying is, and he admitted to that, so as in terms of getting a portion of the proceeds from the, as part of the contract.
And as with any that are here based on the operation without a permit, your task today was determining when he is eligible to apply. That does not guarantee him a permit. We would then look into the ownership and other criteria to make sure he is in fact granted a permit.
Thank you. And that's what I think John had said a minute ago, and that makes it a lot clearer to me now why that was recommended and is accurate, even though just because John said it usually makes it accurate. But thank you. Okay, so it sounds like that what we have is a situation where because of the transactions and everything that has gone on, we have a case where an applicant operated without a permit, thinking that maybe the permit was transferable. It was not. And his testimony is once it was determined that he got his letter, he said they did, after a few rentals, they did cancel the rest. And I mean, to me, because they didn't cancel all the rentals, that, if they canceled all the rentals, usually that's 0 to 3. I think this seems to be more kind of in the 3 range-ish to be eligible to apply, and based on the information that we have, that eligibility may or may not be in question, but that's not for us to determine. So unless anybody else has any other thoughts, or I'll make a motion and then we can discuss it if there are other thoughts, that we allow the applicant to apply for a permit 3 months after the date that the application was filed.
And I second that.
There's a motion and a second, and just for this is your first case, that the rule is that if they rent without a permit, then we can allow them to reapply for a permit anytime up to a year. So a year is the maximum penalty, and we can determine anything less than that. And my motion is, because he didn't cancel all of his listings immediately, but he did cancel most of them after getting his letter, that he would be eligible to apply 3 months after the application date on his appeal.
Does the fact that he's listed as a host on the website as of March 21st, 2019 impact your analysis?
Well,
I'm just asking.
Well, it's one of those things where you don't, if there wasn't testimony, what we'll hear from the code staff sometimes is, is it actively, are they actively renting it? Are there reviews? And what I heard from Mac was that there are 3 documented stays after the change of ownership, which is what he basically kind of said. And usually what we have heard from a lot of different people is that every 3 months it might pop back up and it'll show, but there's not evidence of renting and there's not evidence of other bad behavior. And sometimes you think there might be, but you can't catch it, and you got to use your gut on it. And I think usually there's evidence if the codes folks have come and said, it's active, it looks like you can make a reservation, then that absolutely would change the way I feel about it. But since it was just listed, and he gave an explanation to say, well, there are other properties, and maybe that's why it popped up, then that's where I say, well, okay, well, you can apply. That's why I made the motion that you could apply in 3 months rather than a longer period. But typically, if they are actively listing it, or if they get a letter from codes that says, hey, you got to cancel all your listings, you got to do all this, and they just don't, then that's where you say, okay, you got to wait a year or 9 months or some other period of time. And so that's the logic, for good or bad. So we have a motion, we have a second, and any more discussion or thoughts? Okay, all in favor of the motion, say aye, raise your hand. Any opposed? That motion passes. You're eligible to reapply for a permit 3 months after the date on your application.
Great, thank you.
Next case, 2019-094, involving property at 241 Ben Allen Road. Is the appellant here? Yes. Is there anyone here in opposition to this case? Seeing none, the appellant will have 5 minutes to make your presentation after Mr. McBroom makes the presentation on behalf of staff.
This was advertising and operating on an expired permit. The permit expired on 11/1 of 18, 12/10 of 18. The host letter was sent. Estimated delivery would have been the 16th of December. On the 19th of December, the advertisements were removed. November of 2018 was the last documented stay. On January the 19th of this year, the appeal was filed. No documented complaints on this property, no other actions taken. However, the concern is that the Airbnb ad reads that the appellants live in Kentucky, and their Facebook page indicates they live in Burkesville, Kentucky.
All right, if you would state your name and your address and why you're here.
My name is Patrick Clark. Live at 241 Ben Allen Road. I'm just here to appeal the denial of our short-term rental. My girlfriend pretty much runs the Airbnb website, and she does live in Burkesville, Kentucky, but I do live at 241 Ben Allen. I work here Monday through Friday. Sometimes go up there on the weekends to help out.
Okay, is that the only property that you own in Nashville?
Yes.
And that is your primary residence?
Yes, sir.
You still have a driver's license that says Ben Allen Road and
yes, sir.
Comply? Okay.
Yeah.
And when you got the letter, and you had a permit, you had a valid permit, and it expired, I guess you
just forgot, and we didn't know until we got the letter. I think it was about a week after it was sent, and then we canceled everything that day, took it off Airbnb, actually that night that we got it, and yes, appealed as soon as we could, and yeah.
Okay. Any questions for that? Anything else to add? Anything else for you to add?
No, sir.
Okay. All right, we will close the public hearing. I mean, I really do appreciate the staff digging into the information, and I think that the explanation it makes a lot of sense. And other than, I think unless there's additional concern over the applicant's eligibility in terms of residence, which will be determined on the application, I think that the applicant has done everything right, and our code's timeline tends to support that in terms of removing all the ads and canceling stays. And because it's an expired permit and they've already gone through the process, and it, in my opinion, is like forgetting to renew your car tag, I will move that the applicant is eligible to reapply for a permit on Monday, and assuming that the applicant will satisfy the residency needs or requirements for the permit. But again, that's not totally our concern right now, but I will move that the applicant's eligible to reapply for a permit on Monday.
Second.
We have a motion, we have a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? You're eligible to reapply for a permit on Monday. You don't have a permit, so make sure you get a permit before it goes back up on Airbnb and that type of thing. All right, good luck.
Next case, 2019-099, involving property at 1800 Seminary Street. Is there anyone here in opposition to this case? Seeing none, the appellant will have 5 minutes to make your presentation after Mr. McBroom makes a presentation on behalf of staff.
On June 22nd of 18, the first online activity occurred. There were 42 documented stays at this property. On December of 2018, the host letter was sent. Estimated delivery would have been December the 16th. December the 18th, December of 2018, 6 documented stays. Ads removed on or before January 16 of this year. Appeal was filed on 1/29 of this year. There are no documented complaints associated with this property, and no other actions were taken.
All right, if you could state your name and tell us why you're here.
Yeah, sorry, absolutely. My name is Joseph Fitzpatrick. I live at 1800 Seminary Street, and I'm here to request a variance on the denial of my short-term rental permit. Just to provide some backstory, my wife and I moved into the house in, I believe it was late May, maybe in early June, but I think it was late May. And we began using the extra room in the house shortly after that to make some extra income using Airbnb. In January, and this was my fault, I think the letter was delivered in December. It wasn't January when I saw the letter. I think it was just in some other mail and I just didn't see it. But found the letter in January and had some email correspondence with somebody else who works at the office that sent the letter. And from there, basically it was pretty clear, you need to shut the listing down, cancel all your reservations, and you can apply for an appeal after that. So that's what I did. I shut the listing down, canceled my reservations, and then applied for the appeal. Now I'm here. As the gentleman stated, I haven't received any kind of complaints or anything about the house while we've been using it for Airbnb, and I've tried to make an effort to make sure that none of my neighbors ever had any complaints or were harmed in any way from my wife and I, having guests at our house. So.
And so you said you rented a room in your home. Were you always home?
Mm-hmm. Yes, sir. My wife and I both lived there.
Someone in your family was always home when it was rented?
Yeah, I mean, we weren't. I mean, there were times like we were going to work and stuff, but we both.
But you didn't rent the whole house. You didn't.
No. We both stayed in the home. Yes, sir.
And what was the last day that you rented the house?
It was. I don't remember the exact day, but it was in mid-January, which was when I emailed the gentleman who had sent the letter.
Okay. Yeah, I think the ad came down on the 16th of January.
Okay.
So it would have been before the 16th. You got the notice and then you canceled everything after that.
Yes, sir.
You haven't rented it since.
No, sir.
Okay. And then tell me. Any clue as to why you didn't know you had to have a permit?
I just didn't know. I just wasn't aware, which I understand that, being ignorant of the rules doesn't mean don't have to follow the rules. But I literally just didn't know, and then I got the letter, and it was, I mean, yeah, it was kind of a huge shock, but yeah, definitely, my wife and I were in the wrong. We just didn't realize that it was a requirement.
Any other questions? Anything else that you have to add?
No, sir. Thank you.
We'll close the public hearing and have discussion.
Well, there were 42 documented stays before.
Yeah, over 6 months.
Yeah, that's concerning to me.
Yeah, and I mean, I see, and, I guess to me, the question is, did you know or not know? And if you knew, and we don't have any way to really prove that, and if you didn't know, then whether it was one stay or 100 stays, you didn't know. I mean, you know what I'm saying? You didn't know, and so that's what I struggle with. Is I agree. It's like, well, you've done it for 6 months, and yet, how did you behave when you actually got the letter? And do I believe, I mean, what kind of sincerity do I think you have in terms of saying you didn't know? And I don't know what else you can go on other than the testimony, but I see your point. I mean, it's like, what do you do with that?
And I'm not weighing in on the credibility here. I'm just saying it's concerning to me that there's that many stays. We usually don't see that many, I don't think.
And I agree with Mr. Pepper. It's kind of concerning to me. I do believe that the applicant is contrite, and I take him at his word, but it's also, that's a lot to operate without the permit. And then I think back to the summer and all the stuff that was going on in the legislature and all the lobbying that was going on in the legislature. And so I just think there was a lot of awareness around this issue. Now, that doesn't mean he knew about it, but it's just sort of concerning, the number, and then sort of the heightened awareness around it during that time.
Yeah, and I appreciate that, it is shocking to me because to us it's so obvious, and we're all active in neighborhoods and it's obvious there. But I'll just go and ask friends and people I know, hey, what do you know about this? And it's still just to test it, because we do have so many people that come and say, I had no clue. And so I don't know. I guess to me, I view this, and again, it's up to you all too, and not trying to sway you one way or the other. I'm just telling you where I am. But I view it as in terms of behavior after the fact that it's owner occupied, the fact that it's a room in the home, and that the owner is there during the stays, and the fact that they I think did things right afterwards. I think it's in that 3-4 month after period after the last rental, which was the 16th of April. So I'm thinking, sometime 16th of January. So 3 months would be 16th of April. I'm thinking 16th of April to the 1st of May, and as being eligible, meaning it, kind of in that first quadrant of severity. I don't think it's necessarily apply tomorrow, because I think, like you said, there were rentals, but
I don't know that I'd be okay with May 1st. I don't think it needs to be anything close to a year, but I just comfortable with May 1st. I think something a little bit more than that I would be.
Well, how about I'll make a motion and see if it doesn't pass, but I'll say that the zoning administrator did not err. The applicant did rent without a permit, and the applicant will be eligible to apply for a permit 4 months after the last known rental, which would be May 16th.
I would second that.
Okay. There's a motion and there's a second. Any other discussion?
So the day he would be able to apply, just so that I understand your motion.
He would be able to apply for a permit May 16th, and they would have to go, and again, once you have to reapply for a permit, you have to go through the whole process again. So you have to go through the whole process again, which means you probably.
I support your motion.
Okay. So there's a motion, there's a second. Any other discussion? All in favor of the motion, say aye.
Aye.
Any opposed? So you're eligible to apply for a permit on May 16th, and just make sure you have a permit before you rent your house.
I will. Thank you. Thank you so much. Have a good day.
All right. Next case.
Next case is case 2019-101. We just heard 99, right? Sorry, I got distracted. Case 101 involving property at 1402 17th Avenue South. Is there anyone here in opposition to this case? Seeing none, Mr. Henry is here on behalf of the appellant. You'll have 5 minutes to make your desired presentation after Mr. McBroom makes his.
This is for advertising and operating on an expired permit. On June the 5th of 2015, a Type 2 permit was issued. It was renewed 1 year later. A year following that, which would have been June 5th of 2017, the permit expired. On October 27th of 2017, the host letter was sent. Estimated delivery would have been 11/3 of 17. Still in violation, warrant requested, warrant return not found, alias warrant written, return not found 2 more times. The appellant apparently...
And Mr. McGrew, will you tell us what that means when you say you...
It means that the address on record is inaccurate, and so the warrant cannot be served by the Sheriff's Department. And then after a certain period of time or a number of attempts, one or the other, they return it and file it as not served, not found. But eventually, the appellant came into the Coast Department, is my understanding, and was served at that point in environmental court on...
And do you know when that was? That was at 1:30?
1:30, yes, sir. Same day as the appeal was filed. The first environmental court hearing was on February the 20th. A continuance was asked for and granted, and that was changed, but my most current records show that it's for the 17th of this month is the next hearing at the environmental court. On 1/5 of 19, the advertisements were removed. There were 26 documented days after the permit expired, and 21 documented days after the host letter was sent. There were no documented complaints associated with this property.
Okay. Any other questions? All right. Tell us what happened. And
Chairman Taylor, thank you. Sean Henry, representing Perry S. Hurst, the property owner here. To my right is Shane Horton. He's the property manager. Mr. Hurst was here. He flew in from Arizona 2 weeks ago when we had the hearing set, and but because of a film shoot that he's involved in professionally and contractual arrangements, he could not be here today. But Mr. Horton's prepared to answer on his behalf. I have handed out to you a letter with some attachments that I really just put together a few hours ago after going back and taking a fresh look at the state law. Before I dive into that, I'm going to give you some of the background facts here. I know you want to know sort of the history of things, the background of things. Mr. Hurst bought this property on Music Row, and by the way, this is commercial zone property. It's office and residential at 20 dwelling units per acre. It's a historic structure. It has 6 units in it. He's never rented on a short-term basis more than one of those units, one unit, single unit, Unit B. But he bought this property in 2014. In January 2014, you have his affidavit. And as of October 1st, he began leasing that particular unit for short-term rental purpose. And I have now attached that lease. I just really got that a few days ago, but I've attached that to my letter to you here dated today. And I think that's important from legal perspective, and I'll touch on it in just a moment. So he started renting the property out October 1st of 2014, well in advance of Metro having any law in effect to address short-term rentals. But it was on the cusp because Metro then introduced several laws, Statute 909, Metro Ordinance 909, Ordinance 951. The earliest of those were enacted in February of 2015. So he was already using his property for short-term rental basis. The law passed. He's then informed in some fashion that Metro now has a new short-term rental permitting process. And so he comes down to Metro Codes, he applies for that permit, he receives that permit June 1st, 2015. He renews that permit 1 year later. And then in 2017, he failed to renew it. And what he's told me is he was having some trying times in his life. He was going through a divorce, and it totally slipped his mind. So he didn't renew it, continued to operate. What's interesting about the failure of him to receive notices or reminders that he needs to renew appears to be attributable to the address. The address on record with his permit is Frank Lloyd Wright Boulevard. It's North Frank Lloyd Wright Boulevard. That is his address. Yet the notice of violation that's dated October 27 of 2017 is addressed to North Wright Boulevard, and that's Exhibit 3. So the important words of Frank Lloyd or Frank L. is not in that address. It was never delivered to him. He never received it. He believes that's the reason that he didn't get it. When he was informed that Metro had, and the way he learned this was there was a real estate agent shopping the property for a buyer. And the buyer had done some due diligence at Metro Codes and discovered that this notice is in the record. So the agent informs my client, hey, there's a problem downtown at Metro Codes regarding your short-term rental permit.
And do you know when that was?
That was December 5 of 2018. Mr. Tomey, who's a real estate agent, was taking a tour at that time. And so my client immediately, that was I think a Wednesday, December 5 I believe is a Wednesday on the calendar, he immediately tried to reach out to Metro Codes officials and find out, left several messages. By Monday the 10th, he had an email exchange with Inspector Robert Osborne. That email exchange is in this attachment beginning at, I think this is Exhibit 4. And so my client contacted him and said, I learned from a broker that there's something wrong with my permit. What do I need to do to fix it? Mr. Osborne responded that same day, trying to figure out what the mailing address is, et cetera. So that began the discovery that there was an address issue. Nonetheless, my client then hired me and said, what do we need to do to get my permit renewed? And I said, well, we need to go down and talk to Codes. If your permit has expired, I don't know why you simply can't apply to renew your permit. It's not subject to the owner-occupied limitations. This is permitted by right in the OR 20 district with conditions. And so long as you meet those conditions, you get your permit. So he went down through Mr. Horton's assistance and his wife and applied for that, I think, on January 29. And of course, the position of the Codes Department is if you've been operating without a permit, we can't issue the renewal. You got to go to the Board of Zoning Appeals. And so here we are. So that's the background in a nutshell. He has never attempted to skirt the requirements in any way. I've got a packet here I'm happy to supply for the record if it's interesting to you at all, where he's paid all of his taxes, right? Hotel occupancy, business taxes, et cetera, et cetera. So that's the background on the permit.
Okay. Are there any questions? So there was a legal permit. The owner had to follow all the rules in 2015 to get a permit, renewed it, forgot to renew it, and because of the difference between Frank Lloyd Wright and North Wright, that's the reason that the applicant never got the letters, and the applicant, I'm just making sure I understand, you're testifying that the applicant took the initiative once he heard to start correspondence, and that's what got us here.
Yes, sir. And there's been no complaints of record. In fact, the two property owners on either side have letters of support in the file. Councilman Colby Sledge initially was opposed just as a matter of course because it was operating without a permit. But when he learned that the two adjacent property owners were in support of this, he moved his position from opposed to neutral. That's now in your file as well. So
that's right.
This Music Row, there's nobody over there that's being affected by the operation of this single unit.
Okay. Any other questions? Okay, we will close the public hearing.
Well, if I may, Mr. Taylor, those are the facts. I do want to make a point of law.
Okay. Okay, we will give you, your time's up, but I'll give you a couple minutes.
Well, I apologize. Just real quick, so I've handed to you a letter. The state law that went into effect last year in 2018 says, and this is on the front page of my letter, an ordinance, and the very first ordinance that we're talking about here that Metro enacted to regulate short-term rentals was February 26 of 2015. What the new state law says in 2018 is that an ordinance that regulates the use of property as a short-term rental unit shall not apply to property if the property was being used as a short-term rental unit by the owner of the property prior to the enactment of the ordinance. So my client was using the property as a short-term rental on October 1st of 2014. We had the lease here, signed lease with an occupant. That's attached to my letter. October 1st, 2014. Not until February of 2015 does Metro enact a law to even regulate short-term rental. So what the state statute is now saying is that my client's protected. He was operating, he didn't have to have a permit because there was no such thing as a Metro permit in October 1st of 2014. He was legally operating. He can continue to legally operate that short-term rental. Now, he did voluntarily subject himself to the Metro permitting process. He came in and got one. But he certainly hasn't waived, and that all predates the 2018 enactment of the state statute. But when the state legislature enacted what they enacted, they basically said, look, any law that's now come after you've been operating has no effect on you. And so I want to be sure that, you know, we want to preserve our rights to make that argument. I don't believe my client is required to have a permit at all because of the state statute, because of that very express language that I just read. My client doesn't have a problem in going forward with the renewal of the permit. I just want to be clear here on the record that my client's not waiving the right to assert under the new state statute that they're not required to have a permit at all.
And just to make sure I'm clear though, this property is zoned OM20, which allows your client to have the type of permit that he's seeking. So there's no issue there. If we said that the applicant's allowed to apply for a permit at some time after today, then there would be no issue other than having to get a permit. And if that's the case, then we don't really need to address the other legal issue. That is correct?
I just want to reserve my client's rights to rely upon state law because the short-term rental permit statute, the local ordinance, I mean, we got 4 or 5 of them, maybe 6.
Absolutely.
There may be a new one next month. Okay, so I just want to be clear, we're not waiving my client's rights under that.
Absolutely. So that, just want to make sure that you wanted to make sure you put that on record, and
yes,
and if that becomes something that we need to talk about, but I just wanted to make sure that if I were to view it more simply, as I have other cases like it, then that too could satisfy the needs of your client.
Yes, sir.
Okay. Are there any other questions? We will close the public hearing. Discussion. I mean, there's a lot of strangeness to the timeline, and on the surface, the timeline is troublesome. Other than the very obvious, North Wright versus North Frank Lloyd Wright, which, I think that most cities have a Wright Street, and I don't know how many have a Frank Lloyd Wright Street, but that seemed to make sense, and there does seem to be evidence that once it was known that there was action taken and there was a valid permit at some point, and so, I mean, to me, this does kind of fall into the category of an expired permit. And while it may be troublesome that there was a lot of rentals since the notices were given, there's no evidence that the notices were received. In fact, there's evidence that they weren't, and that it was going to the wrong place. So I'm inclined to allow the application process to continue next Monday. I mean, is that?
I feel the same way.
I'd second that.
Okay, then I will make that seconded motion formal by saying that the zoning administrator did not err. The applicant did operate on an expired permit. Based on the circumstances of the case, the applicant can begin the reapplication process on Monday. And that was seconded by Mr. Pepper. Any other discussion, thoughts? Okay, those in favor of the motion, raise your hand, say aye. Aye. Opposed? It is 3-1, and so that means that it will carry into the next.
That's right.
Into the next hearing, and we can have that reviewed, and any of the board members that were not here can review the case and vote. Thank you.
Next case is 2019-102 involving property at 5161 Pebble Creek Drive. Is there anyone here in opposition to this case?
Yes.
Seeing none, Mr. McBroom will make the presentation on behalf of staff, and then the appellant will have 5 minutes to make his desired presentation.
This is another case of advertising and operating without a permit. The first online activity occurred in July 24th of 2018. October the 5th of 18, the host letter was sent. Estimated delivery would have been the 12th of that month. 30 documented stays, 12 in August, 12 September, 10 in October. On October the 17th, the ad was removed. And on the 30th of January of this year, the appeal was filed. There were no documented complaints on this property, and no other actions were taken.
All right, tell us what happened. Wait, I'm sorry, give your name and your address first, and then tell us what happened, and press the little button on your, there you go.
Yeah, I'm Christopher Lomenfo. So we live at 5161 Pebble Creek Drive in Antioch. And some time ago, we just tried to get something to add to our income. So I went online just to find something, and I saw Airbnb. So we registered with them, and immediately we registered, we saw people becoming interested. We never even look back to say what are the requirements or what else we need to do. But we just did the registration. So after the registration, I called my brother. I said, this is what I want to do. He said, I mean, did you know if there's law behind it? I went to read the Airbnb rules. I saw something. That was when I came to the office here to tell them that this is what I just started. And they told us the requirement to bring. So we were working on all those requirements. Actually, that July, when we did it, there was nobody coming in. But they were making some comments about the room because it was downstairs in my house. So because of that, that was what gave us the encouragement to just stay. There was nobody coming in then. So when it was around September, people start enrolling, trying to come, and some people book like ahead, you know. So when this requirement thing come up, when I came here, they told us to bring this, bring that, bring that. I said, okay. But one of them was we have to have like 1 million insurance for a home. Then I thought, I said, we just put this thing very low. The price we are putting is low. Where are we going to get that? But anyway, I said, we have to. Then, that is when we came here, they gave us all these requirements. We were just looking on what to do and how to get it. That was when I came back again. They told us we have to close it immediately. In fact, we were even thinking of closing it, because we never want to go against the rule of or the law of the land. So that one, we are very sure about that.
So you got a letter in October saying, hey, you're supposed to have a permit that you said you didn't know you're supposed to have because you got on Airbnb and it didn't say.
Yes, it is when we went back to the Airbnb to read all the requirements. That's when we knew about that, we came here.
Oh, I see.
Yes, we came here, they gave us all the requirements. So we were working on getting all the requirements and getting the insurance, all those type of things. That was when they brought this letter.
And do you only, you just rent a room in your home, or do you rent your
whole home? Downstairs in my home.
So you rent the downstairs?
Yes.
Is it like a one bedroom?
Just one bedroom.
And
a kitchen with it, yeah.
Okay. And then, so what was the last day that you rented the house?
I think before the letter came, I can't remember exactly the date. I'm sorry. I think.
Well, like the 1st of October, the last of November.
Okay. The first, like I told you, people book ahead. So the last one would be November ending. Somebody said he was going to stay there from 1st of November to end of November. Then I called Airbnb. I said, we have problem. We need to close it. Airbnb told us that we're going to be paying $50 every day if we close it. $50 per day. Then I said, we cannot do that.
Did you tell Airbnb you didn't have a permit and that's why?
I told them. I said it's because I didn't know that I need to do that from the beginning. That I'm sorry, we need to close it, but they told us you have to pay this fine. I said, yes. So because they already booked, we just left it. But we already closed it down when the letter came.
So what day was the last day that you rented?
Yeah, that would be end of November.
Okay.
Because it has already been booked ahead, so we cannot.
But did somebody stay in your basement? I mean, in that room?
No.
In December?
It's empty till now. We have cut it, removed everything online.
Okay.
Since then. So this, in fact, they told us to pay taxes. We pay all the days taxes that people rented the place, and then next time they send me a code to start paying. Because I've already paid all the things I'm owing, that's the taxes. So they send a code to me so that we can be paying every month. Then I kept it. I said, probably there was a mistake somewhere. I don't have to because they already told me to stop, and they are now sending me a code to pay again. I said, no. That's how I said I have to come. They told me to appeal.
Okay.
So that's why we're here.
Great. Any questions? All right. Anything else that you have to add?
There's nothing. I just want to say that when we operated it help us a little bit because I have a big family, and it was like some income coming in from somewhere, which is not bad,
Okay.
Yeah.
Great. All right, we will close the public hearing and discuss.
Yes, this case is like many of the others, and I think I would be willing to go along with a motion to give them permission to apply immediately or Monday.
Okay. And I was thinking, kind of 3 months after the ad went down, which would have been the same thing as your motion. Even 3 to 4 is just very close. So your motion is that the zoning administrator nearly
did not
apply on
err,
Monday.
and that because of their circumstances that they will be able to apply for a new permit on Monday.
Okay, I'll second that motion. There's a motion, there's a second. Any other comments or thoughts? Then all in,
I was just going to say, I think this is like the one that we heard a couple cases before where the gentleman didn't know and he seemed very contrite, like this couple did. So whatever was in line, whatever we did in that one, I think is consistent with this one, so.
and I think, yeah, and it was, I think it was pretty much the same.
His may have been a little bit longer, but he had 42 stays. And
a lot more
so
rentals over a period of
he had
time.
a lot more, so I can support your motion.
All right, so there's a motion, there's a second, and we've discussed. All in favor, say aye, raise your hand. Any opposed? Then that motion passes. You are eligible to apply for a permit on Monday. You don't have a permit, you can apply for a permit, so you have to go to codes and reapply for a permit, and then once you have that permit, then you can continue to rent your house. All right, good luck.
Case 2019-111 involving property at 3902 Park Avenue. Is there anyone here in opposition to this case? Is the appellant here? Mr. McBroom will make the presentation on behalf of staff, and then the appellant will have 5 minutes to make their desired presentation.
This is, again, is advertising and operating without a permit. The first online activity occurred on June the 2nd of 2017. There were 21 documented stays. In February the 10th of 18, the host letter was sent and received on the 16th. On the 20th, Ms. Hoffman emailed Mr. Osborne and indicated that she did not know that she needed a permit. Mr. Osborne emailed Ms. Hoffman informing her that she needed to cease operating and cancel the bookings and come into zoning to apply for a permit, and at which point she would have to appeal. However, it came to light that Ms. Hoffman and Mr. Henderson is associated with Sunny Meadows, who I believe is the appellant on this case, had a permit for 1504 18th Avenue South, number 106, since February of 2018. For which the application process began in November of 17. The ads were removed on or before February the 25th of 18. Appeal filed on the 15th of 2018, February 15th of 2018. No subsequent documented stays, no documented complaints, no other action was taken. And the note on this is the appeal was filed and the hearing was requested. Consequently, I had to perform an investigation of which you've heard the findings, but we are now after the one-year prohibitionary period.
Okay, and so do we know why if the appeal was filed in February of last year, why it ended up case number 1?
I'm sorry, there may be a typo, but the appeal was filed actually February of this year. I apologize for that.
Oh, okay, I'm sorry. Okay, I got you. So the appeal was filed February this year, but the ads were removed February of last year. Is that, it says ad removed 2/25/18, or is that?
I apologize. We had a typo on both of those. They're both 19.
So was the host letter sent to 10/19 also?
Nope. No, the first date is correct. I apologize. The ads were removed in 18. The appeal was filed in 19.
Okay, so that's why it's been a year since. So they removed all their ads and on or before February 25th of 18. They appealed this on 2015 of 19.
Yes, sir.
Okay, and therefore that's why the comment of they haven't had an ad or operated that you know about for a year. I mean, there's no documented violations that you.
Not according to host or anything on an independent search which we conducted.
Okay. Awesome. Thank you. All right. So tell us why you're here.
My name is James Matthews. I live at 3902 Park Avenue. To my right is Kevin Henderson, the principal broker at HRG Realty. He represented me in the purchase of the house and helped me file the appeal to be here today. I'm appealing for eligibility to apply for a short-term rental permit for this property.
And when did you buy this property?
bought this property, it was in 2015, I believe. Yeah, May of 2015. It's a historic property. It was built in the 1880s. My fiance and I performed a renovation, and in 2000 and, let me get this right, it was 2017.
Is your fiancée Ms. Hoffman?
She is,
Okay.
yeah. We were operating that together. We found out, we didn't rent the house out previously at all. We lived there for a few years beforehand. We found out we had to move to Atlanta for my fiance's training. She's a resident physician, and we had to move to Atlanta for a year. So we went ahead and moved from our primary residence at Park Avenue out of state, talked to a professional Airbnb management company. They said, oh, this will be a great way to get some income on the house while you're out of state. They informed us they would take care of any permitting and necessary fees for the government, and Airbnb informed us that they were paying all state and local taxes before distributing the money to us. We went ahead and operated with this professional management company and were not aware that we required a short-term permit until we received the letter in February of 18. We immediately ceased operation, took down the listing.
But sir, just, let me interrupt you. How did you not know? Because you already had a permit issued for another property before that time.
That's in the LLC. I'm the president of the LLC.
Well, the LLC operates through people, right?
Yeah.
I mean, it isn't. So how did you not know?
We had a management contract with that property separately, and they did it the right way. It's not something I was hands-on managing.
So you're saying that the permit that was for the other property, you didn't have anything to do.
I didn't have anything to do with that. We were doing this ourselves. This was our primary residence. It just happens to be owned by the LLC. We handled this ourselves.
Who was your management company?
For this property?
For the property that you did have the permit for?
Kevin.
HRG Property Management.
Yeah. Whereas we had this residence managed by Nestive, an Airbnb management company, and they told us that they would take care of it, and they did not. We obviously should have been aware of the regulations and adhered to them, but we were not.
Okay, thank you. Sorry to interrupt you. I wanted
No problem.
to get that question out before I forgot.
Yeah, that's pretty much all I've got. We complied, paid all the money that we owed the state. We had no complaints. Our neighbors support us in Airbnb the property. We live there now. Again, it's our primary residence. It's not something that we're going to rent out full-time or anything like that. It's just something that we would rent out on weekends when we were away, or rent out a front room or something like that.
And so why, when was the last time you rented the property?
The last date of a stay?
No, yeah, I mean, the last, according to the records we were given, it looks like the last time you rented it was sometime in 2018. Is that correct?
Yeah.
Do you know about when in 2018?
I'm not sure. I can find out that information, but yeah, the last stay was a little after we received the host letter, because as the last applicant, noted, there are financial penalties for canceling existing reservations, especially at the last minute.
And then why, and then because you had rented without I'm talking, it's been a long day, sorry.
Mr. Chairman, if I might interject, I think that the rub comes in that it was just short of a year when the application was made for the permit.
Okay, I see. Okay.
So are we eligible to apply for a permit now? Is that what you're telling me? Because I
No, we're just trying to figure that out, but I think we're still in the right spot, so I think we're still in the right spot.
My understanding was we weren't eligible to apply again for another year.
Okay. All right, so is that all that you have?
Yeah.
Is there anything else to add?
No, that's pretty much it.
Sorry, you need to hit, yeah, there you go. Just
Okay. When we started, I'm sorry, I'm Kevin Henderson. I'm principal broker of HRG Property Management, and I represent James and his properties. I did not represent him on the 3902 Park Avenue. We have a multi-unit, the Cambridge condominiums that we started buying up and converted to Airbnbs, and I started the process of going through the Airbnb permit and getting the fire marshal out and all the steps that needed to be done. And as a result of that, I was aware of it, but I wasn't involved in what they were doing on Park Avenue at all. But once the letter came, it came to me, and I immediately forwarded it to them. And I went and talked to David Fabrut over at the codes department, and he said we would not be eligible for 2 years because we were operating without a permit at that time. And I don't know if that statute changed or he was mistaken, but that's why we're here today.
Okay. All right. Any other questions or anything else to add? All right, we will close the public hearing and discuss.
So aren't they about at the 1 year anyway? Is that where we are? Or is it?
Well, they definitely, I mean, it may be, and we can ask the codes, if it may not be that, they've applied and they're eligible after, for a year after they've applied, and I think they came in close but a little late. I don't know if it's a self-imposed penalty at this point, but to me, in practicality, time served is, and there's no documented stay since the 2018, and it seems to me that they should be eligible to reapply pretty quickly. And whether or not they're eligible, I mean, again, they have to go through the application process. I mean, it's an RS5 and it's an LLC. I don't know if that's kosher, but that's not for us to decide because that'll happen in the codes process. But in terms of not having any documented activity for, at this point, over a year, it seems acceptable to me to have them eligible to apply. But it's up to you all too. I mean, to what your thoughts are.
So for clarification, the 1 year would begin to run from?
The law reads that upon a finding by the BZA that a property is operated without a permit, there's up to 1 year from the date of the finding. So technically, the date of the finding would be today.
Okay.
And you have your discretion to lower that waiting period.
Okay. Thank you.
And that may be where the applicant was saying that it might be a 2-year penalty. I have no idea where the 2-year came back. I've never heard anybody say 2-year, but it would make sense if they've already had, in their mind, a year off, and it would be another year, then that would equate to a 2-year. But like I said, I don't know how that is. Well, I will move that the zoning administrator didn't err that the applicant did rent without a permit based on the unusual situation of having it been more than a year since the applicant has any documented rentals, short-term rentals on the property, that the applicant will be eligible to reapply for a permit on Monday.
I second.
I have a motion and a second. Any discussion? All in favor, raise your hand, say aye. Any opposed? That motion passes. You're eligible to apply for a permit on Monday. You don't have a permit till you have a permit, so don't rent it or list it till you get your permit.
Thank you for your time.
Last case is 2019-133 involving property at 805 South 19th Street. Is there anyone here in opposition? Yes. So Mr. McBroom will make the presentation on behalf of staff, and the appellant will have 10 minutes to make her desired presentation. Ms. Watkins, if you would like to have a rebuttal, make sure you reserve that from the allotted 10 minutes.
I'm Kim Watkins. I live at 628 Watson Wood Drive. I'm here in behalf of my boss, Brittany Turner, which is the owner of the house at 805.
The board may want to hear from staff first in this proceeding.
Okay.
This again is a property that was advertised and operated without a permit. Let me make sure that I'm on the correct case. This is 805 South 19th Street? Okay. The first online activity took place on September 29th of 2018. 11/13/18, the host letter was sent and received approximately on 11/19 of November. On 11/29 of 2018, the advertisements were removed, and there was one documented stay in November. February 14th of this year, the appeal was filed, and then one documented stay that took place last month on the 23rd. No other action has been taken. The concern is the property owner has other permitted properties. 1210 Ashwood is permitted and has been since July the 9th of 2015. And as expressed by two council members, which this is not before you, but their objections were that this is a LLC that cannot obtain a owner-occupied permit in this residentially zoned area.
All right, if you would state your name and tell us why you're here.
It's Kim Watkins, and I'm here again for my boss, Brittany Turner, and she is in fact actually the owner of the house, and I can present you with the deed of 805 South 19th Street.
So who is Ariel Global LLC, and why are they listed as the owner of the property?
She owns that company.
So
She owns Ariel.
Right, but why did she, I have a company too, but I would never put it as an address on my personal home if I applied for something in my personal home. So
We build
why is it-
houses.
I'm sorry?
We build houses.
Right.
Right, and it was under her name, and so I guess she decided to buy this particular house. It was under the company, it was under the company's name, and she decided to buy this house. And it's her residence, her driver's license.
So tell me if I'm wrong here. What I see is when the permit was reapplied for in August of 2018, it failed the fire marshal's inspection. And
No, that was, I think, it's the next case.
Oh, last case?
Yes,
Okay.
last case. Sorry,
Strike that. I'm behind the group.
I'm sorry, Ross. When you started down that path, I'd already gone down that path myself, and then I thought, wait a minute, this isn't the right case.
No,
Yeah, it's 133.
Never mind.
Sorry.
Yeah. I have a cold, so I apologize if I sound terrible.
I'm just glad you did the same thing. So when did your boss decide to make this?
In December of last year.
Got this from Brad.
Okay. So the first online activity, though, happened in September, and she didn't decide till December to make it a permanent home? Who owned it between?
Ariel did.
So Ariel was operating an illegal Airbnb because they're not allowed to own it?
I guess so, yes, sir.
Okay. Which is a little bit in line with what our Metro Council at-large member Bob Mendez said, and also our council member Brett Withers has said, that this seems to be a pattern with
And I
the
can't
company.
speak for previous stuff. I'm just here for that one, and that is her permanent address. I do know that.
Okay. Is there anything else that you, tell me anything else you want to tell us?
No.
Okay. Then you will have 7 minutes and 58 seconds for rebuttal, and we'll hear from the opposition.
Good evening. My name is Jason Garrett, 1508 Sevier Court. I've been on the board of this
Sir, I didn't understand what you said.
My name is Jason Garrett, 1508 Sevier Court. I've been on the board of the neighborhood association that includes this address for several years, and there are several relevant material details that may not be apparent in the context of the appeal that voices some concerns that some other people nearby have had. What we've seen in many cases are numerous other present or former employees of the company that own properties in the areas with short-term rental permits, including the principal owner of the property, Ms. Turner. And this would suggest that there's an awareness of the need for a short-term rental permit. Councilmember Mendez referenced this in his opposition letter, that inspiring a natural person amendment to Bill BL 2017-608, which came actually from a property that was operating in that gray zone just a street away. There's an aerial B&B marketing campaign that's linked from the company's website that allows booking of properties, suggesting knowledge of permitting needs. A little background, though. Aerial has demolished or built some 25 projects within our 900-home residential neighborhood in Shelby Hills, and that's located within about a mile of downtown. I can't recall a single sale for under $500,000. Many or most are listing in above 700K. Square footages are in the top 10% of perhaps all District 6 housing. These builds have listed for significantly more than any or most other new construction. Many would suggest financing, or at least its risk mitigation has been subsidizing with advertising that there's a potential revenue stream to assist. That might appear to be the case here. Anecdotally, is other near neighbors have suggested that the house did not sell for its initial listed value. The size and worth of these properties command higher than normal daily rates for Airbnb rentals, and as such have significantly more impact on the area than a traditional owner-occupied use. The appellants did not reach out to the association. I'm not speaking on behalf of the association, so we did not have a time to take a position on the case, although we do recognize the importance, as our location puts us in a very vulnerable position to maintaining long-term residents versus transient investors or investors entirely. At one time in the past, we had nearly 150 listings on Airbnb rentals for Shelby Hills. I would be interested in knowing to what extent the appellant lives at the property, the types of rentals that are occurring or desired, renting as a full house or just a room, and for what asking prices, and with what frequency is this person registered to vote from there. This kind of gives a basis for the impact potential. And it's been alleged that there have been rentals and parties occurring since the appeal application was made. I would request that the appellant speak to this and their rental history. And is it normal that a single appellant lives in a 3,030-foot, three-story house that's listed for over 700K if they just need extra income, as was written as the application justification? At least 6 other persons familiar with this property commented in opposition on a neighborhood association page. And I personally believe that Ariel's done a net positive to the neighborhood, but we would be much more in preference of having actual neighbors buying these houses rather than them being potentially overbuilt for the shorter-term housing market comps and hedging toward future speculation with other means whose long-term consequences are very unclear. There's a great deal of new planning, sociological studies related to the longer-term effects of short-term rentals and its negative effects of gentrification. And we've had cases of tripling property values within a single reassessment period in Shelby Hills. So it's clear that outlier developments such as this potentially couldn't have not influenced those comparable values. Our most significant ability, given the protections that we have now, is to at least comment on how to slow this feasibility given the legislation in place designed to protect neighborhoods. Because Shelby Hills has no overlay, a generous RS5 zoning, 45 feet tall structures at 3 stories, you're seeing exactly what pro-smart growth planners would suggest is a danger of this lack of protection. Very expensive, comparatively overbuilt houses whose short-term potential changes the landscape with very concerning mid to long-term consequences. Personally, as somebody that's invested a lot of time toward neighborhood associations and their implicit roles in Nashville, I just wanted to add more context to the appeal. We didn't know very much about some of the circumstances of the appeal, and also just to express some of the feelings of others who weren't able to attend today. Thank you.
Great, thank you. Are there any questions? Great, thank you very much.
Thank you.
All right, the applicant will have 5 minutes and 98 seconds, I believe, for rebuttal.
With his response, I feel like we should defer maybe if that can happen until the owner gets back into the country. The owner of the actual house is out of the country. And I'm not a lawyer.
You what?
I'm just.
Is there a reason why you didn't ask for the deferral before the public hearing? Because she was out of the country then? I'm just asking.
Actually, I don't know.
Well,
I mean, who's to say who can do short-term rentals and who can't do them? I mean,
The Metro Council is to say.
well, I understand that, but like, I mean, there's a whole ton of people in.
yeah, I mean, I guess that really is not relevant to your request. And I'm not, I guess the question is, are there factual, are there facts that you believe can be presented if it is deferred that were not presented now, and what would those be?
Well,
because I mean, there's been enough testimony, frankly, to rule. It just is a matter of, what is the ruling, and I'm not sure. I mean, your boss clearly sent you down here. Yeah. You're representing. I know you're in a tough situation, and that's. Your boss clearly knew the hearing was today, and your boss didn't ask for a deferral. So I guess
it's her house. That's all I know. So.
Is there any one inclined to?
You know for a fact she lives there.
I do, absolutely.
How long has she lived there?
Since in December. She bought it in December. You'll have all the documentation.
Well, I'm always sensitive to the fact that, like, when neighbors show up and stay the entire time to speak, like, it seems disingenuous to ask for a deferral after we've had the hearing.
Okay.
But unless, I mean, we could ask the neighbor if, like, a deferral would allow time for the neighborhood association to meet with this person and then sort of talk through that. If that's something that he would be amenable to, then I would support a deferral, but only if that would be my question.
And I'm fully prepared to decide today. I mean, and the applicant certainly has the ability to ask for a rehearing if they don't like what we decide. I mean, they can say, here's substantive information that you didn't know about that might sway you, and the owner can come and make that case. And if it's persuasive, then we can have a rehearing. But did you have a thought?
The rehearing standard's a little more detailed than that, specifically if it's information that was not available, not meaning that somebody wasn't in town to tell it, just that it was a document that didn't exist, a piece of evidence that could not have been theoretically had today. So it's a higher standard than merely it was inconvenient for somebody to be here, I just didn't have a copy of the lease on me that day or something like that. But you are correct that there are appellate rights. Even if one of the interested parties got an outcome today that they didn't like, they of course have the writ of cert appellate rights to the Chancery Court.
And we do tend to be pretty liberal in the way we look at deferrals, but I tend to agree that there is an element of disingenuousness to come up with the word at the last minute. But
I'm by no means being that way.
And then I'm just saying I get it. So did you have anything else to add?
No.
Okay. Then I'll close the public hearing, and if there's a motion from the board to defer, then there will be a motion to defer. If not, then we can discuss it and make another motion. I mean, the things that sit with me on this one is I think it's established that the home was not occupied or wasn't the owner's residence till December. The activity happened in September, and it was admitted that an LLC operated that Airbnb, and it's a big company, and I think it was known that wasn't kosher. And so that's where and usually kind of open to talking about it more, but this is one where I don't know that it could be disputed that because of the materials that we were presented, that ownership happened sooner, and the violation happened before the ownership, and it falls right in line with the behavior that was described by Councilmember Mendez and Councilmember Withers. And so I'm inclined to say that to move that the zoning administrator did not err and that the applicant is eligible to apply for a permit a year after the date of the application.
As opposed to a year from?
Oh, from the day it was discovered, which would be today?
Right.
Then that'll be fine. The year it was, the day it was discovered, which is today.
Okay, so that's your motion?
Yes.
I'd second that.
Any discussion? All in favor, say aye, raise your hand. Any opposed? Okay, and then then they can appeal, and if they want to, they can talk to codes.
All right.
Great, thank you.
Thank you. That's it for the meeting today.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.